Advocate Mkhwebane. The time now is 21 minutes past 10. We're only starting now. So I've taken 20 minutes of her time because we're waiting for members to fill up. That's the first, and I don't think that's acceptable. We're not starting at 9, we're starting at 10, and we're late with 20 minutes. We should have started at 10 and everybody was here except the members who have just joined. It's a matter we'd have to deal with perhaps later on. Let me welcome the members who are here and all members on the virtual, those who were early on, and those who have just joined the meeting. Acknowledge and welcome the Public Protector, Advocate Mkhwebane, who was here exactly on time at 10. Apologies for us to keep you waiting. Legal team led by Advocate Mpofu. Evidence leaders, don't know if they slept here, but they were here very early. Advocate Bawa and Advocate Mayosi. Members of the media with us, our entire support staff, and the people who brought us here, members of the public in their various platforms. Welcome to our proceedings of the day today as we continue hearing testimony from Advocate Mpofu, Advocate Mkhwebane. Don't know why he would be making testimony here. Maybe that's what we should do. But anyway, on that light note, thank you very much, colleagues. I want us, having lost those 20 minutes, and we probably are going to be held to it, as I know it. I want to go straight to you, Advocate Mpofu, to start the proceedings. Thank you very much.
Thank you, Chair. My colleague, good morning, everyone. A colleague, Advocate Power, we've just agreed that she's going to make 1 or 2 announcements. Well, the first one is just an omission of something we jointly wanted to do yesterday, but she also wants to raise another issue.
Well, maybe in case both of you forgot, I will allow her to do that if it has to do with this witness in front of us.
Yes, both.
I have an allergy on issues that is
we
outside
know
of that. So I don't know what the two of you discuss.
No, I know. I still have
and I hope it will be about that because you also had issues.
I had issues. No, it's not. No, the only ones, the ones I have are the ones you're allergic to. These ones are fine.
No, I'm allergic to anything that is taking us away from interacting with the witness. I hope that whatever that she's going to raise is not taking us away from that. It's relevant to what we're doing now. So let me acknowledge Advocate Bauer. Thank you.
Good morning, Chair. Good morning, everybody. Chair, it is relevant in the sense that I'll explain in a moment, but let me just get the technical thing out of the way. Yesterday, a clip was produced interposing two verbal utterances of Justice Malambo in 2 separate cases before this committee. And I labored under the misapprehension that what Advocate Mpofu was putting before the committee was him reading out the respective orders. In fact, I had asked and then said to him, but it's in the judgment, we can read the orders. But as it progressed, I realized that what was being given was not the orders that was being read. And in discussing it with Advocate Mpofu, I want it to be clear to members and everybody that that was sound bites out of the judgment that he was handing down on behalf of, I think in both cases it was a full bench. Yes, in both cases it was a full bench.
Yeah.
That Justice Malamba was being recorded. So all that was effectively reading a few lines out of the bigger judgment in doing that. And I think the members must understand it in that context. That was not an order of the judgment. So that's the first clarification that we agreed needed to be made. And the second thing is, Chair, which is maybe a bit more.
Well, my understanding was that would have been done deliberately so because they wanted us to hear those parts.
Yes.
Is that my correct understanding?
You're 100% correct, Chair. And in fact, to make it easier, Chair, you'll remember that on the 16th, when we were last year, we actually then had taken the committee to the actual parts of the judgment, in the written parts. All that was happening yesterday was just to play that same thing. So the references are as they were on the 16th to the parts of the judgment, but which I think we just wanted to clarify, because I think it was me actually who said it was the order. It's the body of the judgment. Yeah.
Okay. Thank you for that, Advocate Bawa.
And the second issue, which I at the outset say Advocate Mpofu doesn't agree with. He's allergic to what I'm about to put to
I'm the only
chair
one
of
allergic
the
here.
committee. So there seems to be a plethora of allergies. Chair, Advocate Mpofu's reached what we all understand to be the end of the public protector's evidence in respect of CR 17. I would like to do my questioning on CR 17 at this juncture. I understand that before he proceeds on to the next topic, which I understand is the SARS/Gordon related matter. I understand that what I'm asking is a different approach, but I do this for two reasons, essentially. There is a lot of matter before this committee. The committee currently has fresh in their mind that which has been put to them over the last few days in respect of CR 17. And so it would dovetail with me putting the questions to the witness now, while it's also fresh in her mind, rather than in 3 weeks' time or 4 weeks' time or 2 months' time, depending on where things go in this inquiry at all, when we would have all forgotten what was being said before that. So that was the basis for it. The second advantage to this means is that the respective teams would have then finished off on a particular section, and we could then simultaneously, as we work up our report, which would make the report writing or the heads of argument rather for that purpose, which comes near the end as a constant. At the moment, it's incredibly difficult to start working on heads where we've got frameworks, etc. But the essence of it on the CR 17, we can actually only get to it by the time all the evidence is finished. Now, I know that this is an inquisitorial process, and hence the committee or the chair has a discretion in respect of how the questioning is to be done. And I've looked at it in various ways. I don't see any prejudice to the public protector in that regard, but it's not for me to raise that. It's for Advocate Mpofu to deal with that. Chair, I can see you disinclined to entertain me. I also don't.
I've asked Advocate Mkhwebane yesterday not to read any body languages. And so I want to repeat that to you as well.
But Chair,
I have if you want to read my body, it will be the most confusing thing you can do, because what you think I'm doing or I'm agreeing to might not be. So please go ahead and not read my body.
We're at 10:30 already. I don't want what is almost an innocuous request on my part to take 2 hours. Advocate Mpofu on it and rule, because at the end of the day, we don't really want this request. If you're going to say no and consider it, bear in mind that this next section is the SARS unit matter, and you may want to say to me, I'm not going to let you do it on CR 17 alone. When he finishes the SARS unit matter, then you take those two issues together, before he starts on CX and Vrede. But at the end of the day, we're going to sit with a lump of information that's going to be left to Days to question on. And that's my only point.
Thank you, Advocate Bauer. Advocate Mpofu, you brought this. So I want to come back to you to quickly respond to what you're hearing. You introduce this.
Chair, no, you're killing the messenger, Chair. I was only asked to give space to my learned friend, but by no means am I party to the, I was party to the first point that she raised, but this one I'm disowning any involvement whatsoever. No, Chair, it's just completely impractical what is being suggested. I'm quite sympathetic to the fact that this witness is not like other witnesses and the evidence is quite bulky. When we're talking about the witness statement already in total is 250 pages. So that alone is unusual. So I acknowledge that. But Chair, what is being proposed is completely unworkable for various reasons. The directives are very clear that witnesses give their evidence and you know, then they get cross-examined in my case, or questions are put by the evidence leaders, and then the members ask questions, and then I re-examine in the case of this witness. Now, imagine, Chair, if we're going to do that for every item, we have about 5, 6 broad topics that Advocate Bauer and I have identified broadly. It's CR17, it's rogue, so-called rogue unit, CX, Vrede, there's one other that just slips my mind. Oh, HR, the HR issues, which is a whole cluster on its own. And then we created another category called other, miscellaneous. Yeah. Now, imagine if for all those 5 or 6 units who are going to do this, that would literally mean we do the CR17, then there's questions put by evidence leaders, questions put by members, re-examination. I don't know, maybe we might even have argument on it. So I'm just exaggerating for effect, but I'm just saying that it's, and then we do that, then we come back and we know already the reason why we had the so-called landscaping, Chair, which you kindly allowed, was exactly because that section is cross-cutting through all the other 5 themes. And it was to avoid repeating it every time we have a new section, we now have to give another long landscaping for a whole day or whatever. That day was spent for the entire evidence, yeah, as it were. So quite apart from the impracticalities, Chair, it would also waste time. I can assure you. Firstly, it's the first time I hear of it. One of my learned juniors, when I was trying to explain it and to sell it to my team, she said, well, I'm giving it away now and I say she. Yeah, well, it was a she.
Well, there are 3 she's there.
Yeah, she's somewhere there. Yeah.
But there are 3 she's there.
Yes. So she said it would be like if there was a case and there was charges of murder and robbery and possession of firearms. Then we say, okay, now let's just do the murder. Okay. And then you cross-examine and finish. Yeah, then you come back and say, let's do the robbery.
That's exaggerating it from the sheep.
A bit, yeah. But the point I think is made. No, Chair, so we're totally against that proposal. It will make the process cumbersome, unwieldy, and unworkable.
May I ask you to pause there so that we don't go, so that I'm able to, so we quickly make a ruling in this regard. I think I hear Advocate Bauer's reasoning, and I think you also agree with that reasoning in terms of the almost acres of information, the bulkiness of what we have to go through. So in that regard, it's persuasive, but quite clearly to Perhaps to remain consistent, I think you've raised a number of issues. The practicality is key because we would not have featured that in our planning. I think that's maybe there's something we overlooked in the planning in that regard. I would want to err on the side of us not disturbing the flow and continue as we've planned. If after the day, the two of you think there's any other as part of the whatever you call the back room in a way of how we deal with that, I think we'll be open to that. But I would want to make that ruling that we proceed as we would have planned, because it's quite a smart thing, because it's relevant to the witness, but it's not what's on the agenda, which I'm always insisting on and consistent. Advocate Bauer.
Yeah, I really don't want, I just want to make 3 points. Firstly, this is a novel process. Secondly,
True.
our timetable has changed along the way all the time. And thirdly, this is not a witness. This is the public protector who is the subject matter of this inquiry coming to give her version. So the rules that apply to witnesses don't necessarily apply to the public protector. I just want to play that, but
Yeah.
you've made your ruling, Chair. I may ask again after the
Yeah.
second section.
That's fine. I hear that too. Thank you for that. I think the issue of it being a novel process is convincing, but I make the ruling because I have an allergy that we introduce rules in the middle of a process, but I will be open to whatever discussions thereafter. Advocate Mpofu, we have taken now altogether 38 minutes of your time.
Thank you.
From the start to now.
Yeah.
So you're starting 38 minutes later. That is noted.
Thank you, Chair.
It will be factored in whatever that we do.
No, thank you, Chair.
So may I now hand over to you?
Thank you, Chair. Chair, let me just go straight into it, but maybe just hopefully not to waste another extra minute. Yeah, I just wanted to just to agree with you that the fact that in fact, it's something I was going to say when I was addressing you, that proposal for it to work, it would only work if it was by agreement between the parties, and we'll continue to engage in. Yeah. Thank you. All right. And I know Advocate Bauer is going to say there are no parties, but there are. You know what I mean. Yeah. Thank you. Thank you, Chairperson. Right, Chair, I did say I was just going to sweep up on a few issues, and I promise I won't make it long, unnecessarily long. Good morning, Public Protector.
Good morning, SC Chairperson, members of the committee, evidence leaders.
All right. So the just 2 or 3 issues just to round up the CR17 issue. The first issue comes from the section of the, just one second. Oh, sorry. I'm told I was given. I was given a reference. But it's if we can go to 5.2.5.17 of the.
Now that's very
violent.
Martin and Tembinkosi Ngoma would not
I
appreciate
don't think
that.
yes,
That's-
destruction
But
of
go ahead.
parliamentary properties. 5.3.2.27. 0.17. Yeah, of the Busasa report, the one we had yesterday.
Yeah, just go there, Tsepo. It's in and out. We'll go in there and get out and come to the Gordon matter. Page number? Page number?
I'll ask the PP to assist. PP that reference to the 350. What's the typed page number?
The reference to
It's 5.17.
5.2.
Okay.
That's the typed page number. Then Tsepo will be able to.
Page 50. Okay, so in the report is page 57.
57. Thank you.
Page 57.
Hmm.
In the Bosasa report.
Yes.
There was a report.
Oh, 56. That's fine.
Okay.
Close enough. Okay.
All
Thank
right.
you, Chair. Right. Maybe, yeah. Okay, that's fine. Just leave it there. I'll ask questions building up to it. Yeah. Now, I just wanted to clarify something regarding this matter, because again, we always have to situate these things in the context of this inquiry. So this inquiry is not a public protector's investigation, neither is it a court proceedings. It has a life of its own. So now and again, as the independent panel said, we'll always have to understand that the judgments were made in a particular context of a review application and so on. So, you know, we spoke last week or the week before that of the big figures. And we established that the CR17 managers, for example, had given a figure of 200 million as the total of the donations. On the one hand, the president in the Zondo Commission gave another figure of 300 million. And here we added up some of the figures, and I think it came to about 1.2 billion. I remember the PP struggled with the arithmetic, but she has since been able to establish that. But I just thought, okay, that might be interesting to all sorts of people. But what we are concerned with here, Chair, which I really want to, this is what I want to zoom into, is actually a minor issue where it doesn't matter whether it was 1 billion, 100 billion, or whatever. Because as I'm going to refer you to the actual requirement for declarations, people will be surprised that the threshold is actually 350 Rand. So, you know, so let's not be bamboozled so much by the billions. The actual requirement is very mundane and ordinary. And which is why, Chair, I wanted to ask you, Public Protector, to take the committee through that paragraph, 5.2.5.17, and maybe read it out first and then explain its significance in your investigation.
Maybe just before you do that, Public Protector,
Sorry,
just a pause.
Just a
at Bauer.
clarification on my side. And admittedly, I may not be paying as much attention as I should have yesterday afternoon. But I'm not sure that I heard the part of where the PP confirmed it was 1.2 billion.
Okay, you'll hear it now. PP, last 10 days ago, when we were talking about I don't want to go back to those figures now. You remember the figures we spoke about, 400 million here, 300 million there, 50 million there, and so on. And I remember putting a question to you, and you then said, well, it's around about whatever. I can't even remember the figure you gave, but you had a disclaimer that you're not good with making those additions. And at least now you've had 10 days to do the arithmetic. Do you have a rounded figure of those amount so that we don't have to go back there and just waste time?
Thank you, Chairperson. Last week when I testified, yes, we calculated, and I said I can't, I did not calculate how much it was, because I said indeed there were amounts of around 400 million, 300 million, 300 million. And I said, I wouldn't say it's a total. In fact, I didn't calculate all of them. And I think I qualified as well that even if we can just calculate and say 300 plus this, that's an estimation. Today, I'm saying it's an estimation of that possibly 1.2 billion. But I'm still saying in that estimation, I remember there were various accounts, EFG2, there is the Standard Bank account, FNB account. So monies were moving from here to here, from here to here. So it's 1.2, but estimation, but it might not, you'll find that sometimes maybe same money moved twice. So it's just an estimation.
Right.
Yeah.
And
the three campaigns managers who were interviewed, they were estimating the amount to around 200 million.
Yes.
Yes.
Okay. Okay. Again, I don't want us to be fixated. In fact, the whole point of this questioning is so that we don't get too much fixated in the numbers. So I'm trying to get out of that mode. But be that as it may, now that you've given that explanation about movement of monies from this account to that account, what role did that very fact play in your referral to the NPA regarding the question of so-called round tripping of the money?
Yes, remember my testimony last week, I indicated that there was movement of money from this EFG2, the attorneys who created the trust. And I must correct today as well, Chairperson, that the reattender trust was created by the, I'm correcting my previous indication that there's various people who benefited or the money was transferred into their accounts. I think when we were showing the articles, that the articles published the information before it was sealed. So it's EFG2, there is reattender trust. The reattender trust, the members of that trust are actually the campaigns managers, not Khumbudzo. Then Khumbudzo as a beneficiary and Bosiwela and I think Siweya, she is the sole director of Pora Farms. So I'm correcting that. And remember, there was the article which was shown of IOL, and I insisted that there was a Mail and Guardian article which showed how the monies moved. and we were supposed to upload that article, and we were still trying to find it. So that article is found. We can just share it so that members, when they go through this, they can see. Because the main intention, Chairperson, remember, was what evidence was before me, which made me to come to this conclusion. So it's just proving that point, that I didn't have any, like, relying on some hearsay or whatever, but it was the evidence before me, which I relied on. So
Yeah,
the-
maybe just so that you walk slowly with us, because I am aware that in that week, you certainly did say Ms. Mkhwebane was a sole director of Reattender.
exactly.
So do we
yes.
understand what the correction is today on record?
On
If you can
record.
just repeat and summarize that, so that because you're now indicating that in fact Reattender, they are members of Reattender beyond. So I just want to be clear in my mind that I follow the correction properly.
Okay, so the Ms. Mkhwebane is not the sole director or the trustee. That trust, the Reattender Trust, the members of that trust are the people who were the campaigns managers. For instance, James Mutlatsi, and then I think James Mutlatsi and Donay were members of that trust. Then there were
Sorry,
others.
Chair, I'm sorry to interrupt. Again, for the same reason as the chair, I think let's give the full names. So Donay, when you say Donay, you mean Miss Donay Nicole?
Nicole.
Yes.
Yes. So James Mutlatsi, Donay Nicole, and then there were other two members. I won't mention them because they are part of that particular trust. I'll mention these two because I interviewed them. And then Ms. Mkhwebane is the director, sole director of Pora Farms. And Pora
Reattender.
Farms is
Sole
the
director of Pora, not Reattender.
yes.
Okay, thank you.
Thank you, Chair. And that, is it Pora or Cora Farms?
Pora
Farms, yes. That's one of the entities that were in, or rather, through which any monies went through? Or
Yes,
received?
and
Yes.
per paragraph 263 of
Yeah.
my affidavit,
Mhm.
I said some of the beneficiaries of donations were senior members of the ANC
Mm.
and officials or functionaries of the CR17 campaign.
Mm.
Ms. Park, Mr. Tukwana, Ms. Siweya, Ms. Mkhwebane. So those were the people where
Yeah.
monies were moving from
Yes.
this linked environmental services account, or either from Reattender directly into various accounts.
Yes.
Yes.
Maybe, again, just for clarification purposes, for those of us who didn't go in depth like you into this, can you maybe explain to the chair, no, not to the chair, to the committee then, the relationship between what you've just said and EFG2? So in other words, was EFG2 the vehicle through which those monies were distributed, or it was one of the entities that you've mentioned?
Donay, I explained that during the interview of Donay, in the report is there. Donay is the one who approached the attorneys EFG2, Edelstein Faber Krobler Incorporated. And then they, within the attorney's firm, they created a trust account. So all donors were depositing there into that trust account, and then they will then move the monies to Reattender, to environmental linked environmental services, and then it's paid to various beneficiaries, various service providers. So that's how the monies move. But then, Chairperson, as I said, that our focus was following the 500,000. Hence, then the uncovering of all this.
Yes. Okay. Thank you. I think both the chair and I are clear now.
So
All right.
you uncovered or stumbled on it?
Chair,
You uncovered or stumbled on it.
I think,
These other issues.
okay, with the 500,000, we were just following the 500,000, then we okay, maybe stumbled or
Okay,
whatever.
no problem.
Yes,
Thank you.
No.
Honorable Mbofu?
thank you. Thank you, Chair.
Yeah, this is a pickup. So are you still
Yes, Chair.
on this pickup before we
Unfortunately,
proceed?
yes, yes.
To-
No, I'm done. We're done with the clarification. Thank you,
Okay.
Chair. I was piggybacking on your clarity seeking. Thank you. So, just to finish that issue, maybe we should go to 31.7.17. This, Chair, is the MNG article that the PP referred to. Remember last week when she said, when we showed that other one with Peter Rampage and there were snide remarks about it, she did say that there was another clearer picture. So again, without going into much, you can't enlarge. No, okay. Sorry, now my age is showing up. I need to to look at the enlarged version. All right. All right. Just take us to not the whole list, but at least some of the entities that you have already identified in your evidence. On that list number 6, for example, is it Pore Farms? Is that
That's the one, yes,
that you are referring to?
which I was referring to, yes.
In respect of which the sole director or member or whatever, if it was a trust, I don't know what kind of entity it was, but the sole person was current Minister Kumbutso Mkhwebane.
Yes.
And which
And
then,
I think, Chairperson,
sorry, just so that we finish that one, according to this, that entity received 8.484,000.
yes.
Okay, now you can make a comment, PP.
According to our estimation, it was around actually 5 point something million, but these ones had this. Hence, Chairperson, I'm saying the calculations, it was estimations and yeah. And then also the 3 entities that made the most financial and transaction. So up there, it shows this linked environmental services. The one I said, some of the campaigns managers were part of the directors. Tsepo, if you can just scroll down. Then there's Reatenda. Then there is this Edelstein, Faber, Robler, because they are part of the report. Tsepo, if you can scroll down. Yes, up there, the 3 entities. So that's the most relevant information which I have in the report.
Right, yes, and again, just to remind people, Edelstein, Faber, Robler is EFG.
Yes, correct.
Yeah, okay. Right. Okay, Reatenda is also there. It's got 18,727,000.
Yes. Then we've got linked environmental services.
Where's that? Oh yes, linked is the last one. Oh, with 8 million. Okay. Then the others we haven't. It's individuals or entities by the look of things. Okay. All right. Thank you.
Okay.
Thank you, Chair.
Okay, thank you.
Yeah. All right. Now,
You will keep your promise.
I will,
You-
Chair.
you're just reflecting on this.
And
and what I want us
unfortunately, yes,
to go to what we're
to
supposed do
the
today.
actual issue, yeah.
Yes.
Let's go back to that that page with 5.2.17. Yeah. Thank you, Chair. All right, while SEPA is doing that, let me just develop the point that I was at the point where I was asking you to read the yes, thank you. 5.2.5.17.
Actually, SC, I think just to clarify, let's start from 5.2.5 because that's the response of the president to show
Okay.
that we've incorporated it in the report.
Yes. Okay.
And he is addressing exactly that 500,000
Okay.
issues in dispute, because how we structure our reports, Chairperson, is that when a complaint is lodged, I explained yesterday, then we've got various issues. When we have an issue at the beginning of our investigation, then all the evidence we are collating, we will have to get the evidence of that issue. 5.2, the issue was whether the president improperly and in violation of the provisions of the Executive Ethics Code and disclosure of members' interest for the National Assembly and Permanent Council members exposed himself to any situation involving the risk of a conflict. So, Tsepo, if you can just scroll 5.2, the same issue, 5.2.
Yeah, beginning of that section.
Yeah.
Right.
So this is the issue we were investigating. And then when we investigate an issue, investigators, then we go to common cause issues, issues which are not in dispute. So that's the issue, the 500,000, which was made to was made by African Global into EFG attorney's account, and then for the campaign of the president election campaign.
Okay.
And
Can you just pause the PP again? Because remember, we're using this also as I said to educate ourselves about this, how these reports work here. So the reason that part you say is common cause is obviously because that's actually the information coming from the president himself.
Correct.
When he was making the correction of his answer to Mr. Mkhwebane.
Correct.
And he says, no, I made a mistake. I said it was my son and I looked him in the eyes, what have you. But now I've realized that it's EFG. So therefore it's common cause. Nobody disputed that.
Definitely.
Okay, let's go.
And the common cause also again that even if after the correction, as I told the chairperson yesterday, that we ask all this range of questions because it was about the son. Hence, as well, is common cause that after we received that, indeed, the son as well was doing business, but we were not investigating the son. Then, then that's why the next paragraph I'm saying the issue was the president and his involvement. So now scroll up, Sepo, we go to the issue in dispute. So the president, then it shows here that we've incorporated in the report and we have involved him in the investigation, and then he responds. He, like president, submitted a supplementary statement to my office where he was clarifying the issue of conflict and his obligation of the National Assembly to disclose financial interest received in his private capacity as a member of a political party, because that's what I'm being accused of, that the matter I didn't have jurisdiction. So this is the response directly from the report. This was part of the Rule 53 before all the judges. So he is then acknowledging that in light of your questions regarding the issue of disclosure of interest, I thought it appropriate to address you in this regard. During our discussion regarding the 500,000 donation that was paid by AGO into a law firm Absa Trust account towards my presidential campaign for the presidency of the ANC, you seem to suggest that the donation amounted to a benefit and that it ought to have been disclosed. So that's where the president is addressing that issue. And then he then went further to indicate that he is a member of parliament as a deputy president, acknowledging. And then in my capacity, I disclosed interest as required by the Executive Ethics Code every year. I continue to do so in my, since my election as president in February 2008. 2018, yes. So this paragraph we wanted to go to was then the president acknowledging that he was supposed to, in doing so, and based on the provision, I disclose share financial interest in companies, other corporate sponsorships, gifts, other hospitalities, hospitality, benefits of material nature, foreign travel, land and immovable property, and pensions. So I'm also aware of my duty to disclose such information in relation to my spouse and my dependent children. So that's what the president, it shows that he understood as the deputy president, as the member of parliament, he was supposed to disclose. So then he went further and said, since becoming a member of parliament and a member of the executive, I've taken care to be guided by Section 2 of the Executive Members Ethics Act. Again, the president acknowledging that he knows what Section 2(1) says, which requires the president to publish a code, and then which also indicate that members must comply when performing their official duties. So then we can move to that part which you wanted us to go to.
5.2.5.17.
Yes, then that's when the president is still part of his response that the Executive Ethics Act states that the disclosure of benefits is required. Firstly, it is if it is a material benefit, and secondly, if it's received by the member. Although the donation may be regarded as a material in nature, on the basis that even the gifts above the value of 350 are subject to disclosure. And I think that's what I said. The donation was not received by myself. Instead, it was received by the CR17 campaign in strict confidence. In essence, the donation was not made to a member. So that was the argument which the president has raised.
Yeah, perfect.
And then he went further that I had no knowledge of the donation and therefore cannot reasonably be expected to have disclosed it when it was made, even if there was an obligation to do so, which there was not.
Okay.
Yes.
Fine. Thank you. I think then that, Chairperson, the reason why we bring this to the attention is that, again, we get buried in all this paper. But the essence, 5.2.5.17 and 5.2.5.18 is the essence of this entire thing. Remember yesterday we said there were two defenses, quote unquote. It's I did not benefit and I did not know. So that's where you find those two. The 5.2.5.17 says I did not benefit. The benefit was received by the CR17 campaign. I mean, I don't even know if that's a legal entity. It's just a thing. But apparently that's the thing that received the benefit, not him. So that's his defense there. And then the next, and the thing called CR17 campaign is clearly not a member of parliament. And so that's the purported defense. And then the next one is, okay, even if I had no knowledge of the donation and therefore cannot reasonably be expected to have disclosed it. That's the thing about it was kept away from me. I didn't know who the people were, even though I addressed them at dinners. Yeah. So that was the, thank you. All right, thank you, Chair. Now, the only point really that I wanted to make is that despite the big amounts and so on, as far as you are concerned, the threshold for declaration is 350.
Correct.
So whether it was 200 million, 300 million, 1.2 billion, 10,000 rand, as far as the law is concerned, all you would have been interested in is whether the duty to declare had been triggered.
That's as simple as that. Remember, again, still repeating to members chairperson, members of the public, going forward, know that the public protector, we check what happened, what should have happened, where's the gap there, what is the law saying, and how to remedy that purely. So here, he acknowledged that 500,000 was from Busasa, and he was the member, he was the deputy president. And yes, he says he's declaring, but when we check the declaration, he never declared. And he acknowledged that he participated in the dinners. We had a person who attended who donated, Gavin Watson, but Wes, also before me, I had this evidence which we've shown, that the bank statements, the emails, where he even personally said, move 75 million or whatever to reattender and all those. So that's why when the judges are saying, and even the panel is saying, I second guessed, I think that's what they said. And I didn't take the precedent. So for me, the decision was taken, and when the drafter of the evidence and the analysis of the evidence, which is done by the chief investigator, when it's brought to me, I'm also saying we cannot just make accusation. What is the source? Where is the evidence? And that's what we did. So we were following this 500,000, the donation, and that's it. And he never declared it according to the record in Parliament.
Thank you.
And
I think, Advocate Mbovu, I think you've canvassed that mopping up exercise.
Check if just please just allow me to.
I'm patient because you would have indicated yesterday that if there's one or two issues that
no, it is, Chair, but please, Chair.
I'm eager that we.
Yes, we definitely are, Chair. But
I think
I'm also sensitive to that.
Well covered. Thank you.
Yes,
but
thanks.
Proceed.
Thank you, Chairperson. Yes, no. Okay, I was actually going to start this question by saying, at the risk of the chairperson is stopping me, but that risk is now already occurred. But I do want to emphasize this. As I say, I mean, this is a highly controversial and political matter and so on, and it might get politicized, but we must not be waylaid by that. So the point I'm simply making is that assume the chairperson said you stumbled into all these other millions. Assume you had not stumbled into anything for a minute. Assume you didn't stumble into the bank statements, the emails and all the things. Okay, maybe not the emails, because the emails serve the different purpose, but let's say the bank statements and the other big amounts and whatever. Purely on the basis of the 500,000 amount, which the president himself brought to the attention of Parliament as having been received by the CR17 campaign, and which is obviously more than 350 rand. Just on the basis of that, forget the big amounts. Was your conclusion that there had been a breach of the Members Ethics Act sustained?
Definitely it was, because that was the focus, actually, 500,000. And even if it was more than 1,000 rands or 10,000 rands, and if he didn't acknowledge that and confirm that, and the complaint is lodged, we wouldn't have known about that. We wouldn't have investigated. And the complaint lodged by the DA, not to say me following up or saying, President, you said this, now you're correcting us, the issue of own initiative. That's not the case. I mean, the investigation was done in terms of the Executive Members Ethics Act. Member of Parliament complained, the investigation was conducted. And I think that's why, Chairperson, it's very critical that I place this on record, still repeat. It means then that my version currently, because that's what I'm presenting, considering the fact that certain information is also sealed. And I think it was going to be, and the president acknowledged at the Zondo Commission that it's around 300 million. But then it was also going to help the committee to directly also engage the president on the matter, but you've taken a decision that you are not going to call him as a witness. So I think then the information which I'm presenting, assisting the committee to decide on this charge, then it means my version will be the only version which is before you, and the evidence I'm presenting currently, just to make sure that I show to the committee that this was done honestly without any ulterior motives, and I was just doing my work the best I know how, according to the constitution, the law, and these are the relevant prescripts I followed: the Executive Members Ethics Act, and the president was the member of parliament as a deputy by then when the money was paid, and was obligated as well to declare in terms of that. And when we check the records in parliament, the declaration of this amount was not made. Thanks.
Okay, thank you. Now, you've helped me out. Then I want to ask you about the implications of not calling the president. So the last point then is to round this all up, I'm now spilling out. This last question spills us out of the 500,000. You've answered about that. And we know that we don't have, and you are not at liberty to share the sealed documents.
Yes.
You've referred to all this movement of money, bank statements, emails, and what have you. Yeah. But what we do have access to is what is at paragraph 261 of your statement. And that just gives us a glimpse or a window. Page 261, paragraph 261, Tsepo. And I'll just ask you to comment on the implications of that.
And hide the account, Tsepo.
Sorry, pardon?
Tsepo, hide the account.
Or the account number, Tsepo? Yeah. Just go further up until that line of the account number.
Yeah.
After
so
account number, where it says account number, go more. Yeah. So I'm saying just to close it off then. So you stumble then over all sorts of information, and one of them says, "Hi, Donald. Thank you for assisting with the internet banking and the other day. Could you kindly transfer an amount of 20 million from the money market investment that was left after we shifted? So the person is included himself. After we shifted 75 million from the money market select to reattend the trust standard bank account number blank, 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 then go down and hide the thing from the top that now. In other words, exclude just the following line. Yeah. And it's we can read the part that is not shown, but that is not controversial. It says, I shall call you to confirm all this, signed Cyril.
Yes. And
okay. Now
that shows that he knew he was involved in the running. And as I said, that even these monies which were transferred to the Cyril Ramaphosa Foundation, but this is clearly showing that he was involved. But as well, that the dinners he confirmed he went and he addressed those people who participated.
Yeah. So therefore, to say you disbelieved him or you didn't trust his bona fides or whatever it is, without any reason, which is really what was the conclusion of the court. In the light of this, is that sustainable?
It's not sustainable.
Okay, thank you, Chairperson. That's what I wanted to.
Thank you.
Thank you so much. Okay, right. Okay. Now, All right. Sorry. Okay. I just want the Chair, if you allow me, I'm just going to deal again with this a very small section on the vision here. You'll see the connection. I'm just building up to our next section. If you go to paragraph 154 of your statement,
Okay.
that's 561 typed 65, Tsepo.
154.
154. Right. Okay. So you had what you call Vision 2023.
Correct.
And now it's 2023.
Yes.
Okay. So if you can and I just want the highlights, please, and you'll see the connection when we get to the next big section. So you come into the office, October 2016, you see what you see, you find what you find, and then at some stage you then build your vision for the non-renewable 7-year term ahead. Correct?
That's correct.
Yeah. And you then had and I'm doing this also because of something that we raise in the second statement, but we'll deal with it when we get there, which is that, and I'd like members to keep this at the back of their minds, that, you know, all these cases that we are busy with here are the, what you call it, high profile cases, you know, CR17, Rogue Unit, CX, Friede, and so on. And those are 4 or 5 big cases. And we lose sight of the 50,000 cases of so-called Gogo Dlamini, Mr. Nyatela, Mr. Siabi type of customer. Yeah. So can you just broadly just take us through the headlines of the vision? And they are set out in paragraph 157. The first one is access. The next one is vernacular. The other one is footprint. Other one is agreements. Other one is safe haven. Other one is rights. Then complaints resolution. And the last one, I think, is self-protection. Yeah.
Thank you.
Can you just capture the vision without going into the minute details as to what really you had in mind for your 7 years?
Okay, thanks. Chairperson would, since he sits in the Portfolio Committee on Justice, every time we explain this, but it will help for the members, other members of the committee, but even the public out there to understand that when I joined the institution in 2016, and thanks to also, I need to acknowledge Mr. Themba Dlamini, who was the CEO then of Public Protector South Africa, after we've addressed various stakeholders, and then we said, and then he said, PP, we need to come up with your vision for the next 7 years so that we know what you would want to achieve. So this is the Vision 2023, and it was drafted in such a way that we expand the access. This is a constitutional obligation. Section 182(4) of the Constitution requires the public protector to be accessible. I think during my interview, I remember I was asked, how am I going to make sure that I reach the community of Mkhwebane, Lingana, and all those? So the issue of access was to make sure that because our institution is free, the services you don't charge, and then we address the issue of access. And I think also, sorry, Chairperson, the main issue here is that indeed the focus is on these 5 matters. And I think in the landscaping, we indicated that that issue of sitting here because of the so-called the untouchables. So the focus of my mandate was purely on this. So on the issue of access, That's what we intended to do. And access is achieved through the road shows every year. There's outreach, community outreach programs, which some have been accused that there's monies which were taken. We'll deal with that and explain what actually transpired. But outreach is continuing, and how we can reach a bigger reach of community when outreach is concerned.
Okay, sorry, I didn't want to interrupt, but again, just to assist the members who are listening to this, or even members of the public. So you've just dealt with access. Now, access, according to your statement, then is the first pillar of your 8-pillar vision.
2023.
Okay, good. All right, because you see, we're doing this against the background of what you said 2 weeks ago, or whenever we were here, that when you go to the office, nobody said, here's your job description, here's what is expected of you, and so on. You had to also design what the roadmap should be. And of course, you had to get the buy-in of Parliament. As you say, you presented this vision to Parliament, correct?
It's correct, because every year when I present the annual report, we still take them through this vision and how far we are in implementing the vision.
Okay, good. So that was the second pillar?
It's a vernacular, meaning the 11 official languages, because access, which I always say, it's not about the building or the offices which we have. It's impossible for us to have buildings in every corner of the country. So also the issue of languages, because then taking it from what Nelson Mandela said, if you speak to a person, when you speak in their languages, you speak to their heart. So that also we took into consideration indigenous languages and using community radio stations, all the SABC broadcasters, because they are accessible, and so that people can understand and access this very important institution.
Okay.
Yes.
Okay, the third one?
It's footprint. So since we can't have the resources to have an office in each corner, then we had this footprint to expand our footprint. We only had 19 offices of the public protector, but then the Kuruman one was closed because of the challenges that we didn't have enough people, but then we needed to consider other options. Then other issues which footprint entails is that we identify traditional offices, we identify municipal offices, and engage then with various other departments to expand our footprint. Hence, it will link to agreements. Agreements meaning memorandum of understanding we have with the Department of Justice, COGTA, various traditional councils. We've established a number of service points, because before my suspension, we were also then developing a way of having drop boxes in various traditional councils, so that members of the community, Mkhwebane, Imbizo, Lekgotla, they can then, when they are going there, I mean, a chief or Inkosi will say, my people have a challenge of IDs, Home Affairs is not doing this, or the issues of road infrastructure, children cannot go through. So this was mostly then dealing with that. And my achievement is that we've signed a number of those agreements, and then we are maintaining them. The complaints are lodged. The office will then collect those, and then we process or we refer. That is to make sure that we are a safe haven to the members of the public, the poor, the marginalized, people who cannot exercise their own right to engage and to be assisted by public servants. So that's the other pillar.
So,
and then for us was to make sure that to uproot the issues of the maladministration which is occurring in state affairs.
okay, thank you. that's the chairperson will be proud of you, because in that answer, you've covered the fourth pillar as well as the fifth one, which is safe haven.
Yes, the fifth
Okay.
one, yes,
Right,
safe
so
haven.
let's move to the sixth one.
The sixth one is, in a number of instances, it's only the empowered or those who are educated who will exercise their rights, who will hold the public servants to account. It's very rare that you'll find rural communities exercising their right and making sure that they are holding the public to account. So when we conduct road shows, when we engage with them, and when we involve Amakosi and everyone, using them as our ambassadors as well to engage their communities. So in this instance, we are also then empowering members of the public to exercise their rights. So it's very rare to find Abonya Taylor or Abo Mr. Siabi who are able to exercise their rights and hold those who are public servants or those who in power to account. So this is where we also deal with a lot of systemic challenges. In other words, we are saying to the people, deal with that public servant yourself, expect and demand service instead of complaining, but then you must be on your own and stand for your own right, deal with it so that as an institution, we can focus on systemic challenges and propose policy changes. So the next one is complaints resolution number 7. This one is also very, very critical. Well, the chairperson will know because at the Justice Portfolio Committee, that's where I would say this one also is to make sure that there are sector ombudsman. I mean, I indicated that you'll find the tax ombudsman. When we engage with them, they will tell you in a year we process more than 2,000 complaints from members of the public about delay to pay their tax issues. And if we didn't have the tax ombudsman, those people would have approached the public protector. So more than 2,000 people approaching us because of the delay to pay. So we encourage the establishment of health ombudsman as well, which is also helping the issue of military ombudsman, especially members of the military of the service who are then in communities, and there's something which needs to be resolved, especially it involves the members of SANDF. So this help a lot. And what we've done as well is that engage with like Department of Home Affairs, we've got an MOU with them, all complaints relating to home affairs. Instead of us investigating them, we then collate them. Actually, it has been like that, but now we've formalized that structure and refer to Home Affairs, update us. How far are you in processing Advocate Matlape's ID? How far are you in doing this? Master's office as well, delays in processing the issues of deceased estate. So there's an arrangement that how quickly can you process that? We're doing that so that we remove a lot of burden in the institution due to financial constraints, due to the fact that we don't have enough capacity. So that has been achieved, and a number of bodies have those internal complaints mechanisms. In various municipalities, for instance, Tshwane, we've advised them. Johannesburg has a municipality ombudsman, where members of the public can go to that and complain about service, billing, those manual issues, so that we are not doing the work of the public servants as the public protector. So this is the very critical one, which can help a lot. And so that when members of the public, they can't get assistance from these institutions, then is escalated to the public protector. As a public protector, we only deal with systemic challenges. Then the last one is self-protection. Self-protection, meaning people must be their own liberators. I always say I want each member of the public to be a public protector. So after we've empowered them, and this chairperson, I would say, before my suspension, we were testing the app, because for me, if each and every family, children have smartphones, we have the public protector app. So this one, a person sitting at home, a child will then advise Ugogo, that, okay, you have a challenge with your pension. Let's see, there's this public protector app, if it can be promoted, then they would know that if I have this challenge, which institution can help me? And this app also not only helps the issue of our mandate, or that you have challenges in the public service. You might have the challenge with your short-term insurance. You might have your challenge with any other private company. But what we do is that, because people also come to us thinking that we investigate private companies, which we don't. So this app will tell you, if you don't receive service from your insurance, then here's the contact of the short-term insurance. Here's the contact of the banking ombudsman. Here's the contact. So this was the intention which one had. And I must indicate that it's 2023 indeed, and we've achieved a lot in this particular issue. So those are the visions, Chairperson. In fact, the pillars of Vision 2023.
Yes. Okay, Chair, just allow me one more issue just before the break. All right, okay, then, thank you so much, PP. I think then we'll unless if there's any suggestion that any of those pillars were not achieved or being significantly achieved as at the time of your suspension, and hopefully at the time of the end of your contract in October, when you go back to the office, then we will assume then that whatever reports you gave to the portfolio committee vindicate that statement of having achieved what you set out to achieve, and which you had shared with this parliament. Right. Then after that section, there is and we won't go through it now, so to save time, but just to direct the members, there's a section that deals with your annual reports since assumption of office. And I think you did say, ironically, that you were even, the first report you actually presented to Parliament was not even your report. It was Advocate Matonsela's one. It just so happened. So putting that aside, yours would then, that one would have been 2015, 2016. The one that you were presenting, shall we say, on behalf of Advocate Matonsela.
Yes, it's correct. That's the one.
Yeah. And then, so now from 2016, 17 up to now, you were now presenting your reports, as it were.
Actually, there's a report. It's just that we need to be sure 2016, 15, 16 or 2016, 17. But then remember, a financial year government is that the performance of the institution from 2015 year end of the financial year is April. So it was the year end April 2016. So it was that March, yes. And then it was that report which unfortunately I had to present. And is that report which unfortunately as well caused a lot of uproar, the issue of just the magnifying of my, whatever I say, because it was blown out of proportion that I'm criticizing my predecessor. Why am I not, because that's where the issue of the donations, that report was showing that there were donor funds, which indeed I agree with my predecessor, it was done properly through the process. But then the question was the comments by members of the committee, and being a learning person, also me saying, no, I wouldn't be using donor funds because they've got also implications if you do that. Then I was criticized about that. And that's where as well, Chairperson, the issue of Malunga was raised. It's not me, because the members of the parliament were saying we are concerned about this, as if I appointed Malunga. But then I was then expected to deal with that matter. What are you doing? You need to, we can't have a situation where a person working in this institution is not having. So it's not me who went around and did that. So that's where then
Sorry,
also
was
some of
that-
my problems started.
Yes, and was that the Malunga issue, did it have
Of
to do
security
with
clearance.
security clearance?
Yes.
All right. In other words, to even make it even more graphic, the members of parliament were rightly so raising with you the issue of the absence of security clearance for the deputy public protector, but that would have been against the security policy that Professor Madonsela had introduced, not you.
Definitely, but again, it's just that sometimes, yes, members of the committee were concerned that during the interviews, because that's what transpired. I mean, they are members of the public, they are representing members of the public, I'm members of parliament. So that's where they raise those issues that there's this issue and then public protector deal with it. So by then, I don't know whether they knew there was a security policy, but then it's me who discovered all those, okay, what is happening? And especially having worked as state security for 3 months, besides at Home Affairs, when I was working there, being deployed to China, it was a requirement at that level to be having a security clearance. So for me, a lot of things I discovered when I then was in the office and promising members of the portfolio committee, because that's where I account on the operations of the institution. So I think that's where some of the unnecessary attacks and wrong reporting by the media started.
Yes. And
Okay.
sorry, Chair.
Sorry, just on a bit
Surplus.
of clarification. I'm not clear whether it was raised during Mr. Malunga's interview or whether the portfolio committee raised it. Can
Yeah, okay. I thought she meant the interviews for the public protector, but I was just assuming. I think let the public protector explain. Where was this matter raised, or how had it arisen for it to be raised in your first encounter with the portfolio?
During my first encounter with the portfolio committee was when I presented my predecessor's annual report.
Right.
And it was, I was appointed 15 October, which was a Saturday. So I started on the 17th of April and I was supposed to appear before the portfolio committee, I think on the 19th of October or 20th, that week.
Same week.
Same week. So chairperson, it was there. But what I'm saying is that I was accused as if I am the one who did all those, and the very same person was appointed by them as members. Because when the deputy public protector is appointed, the public protector is not even consulted on you, are not even asked anything. So, but then they told me, you need to deal with it. What policies do you have? We cannot afford to do this. But I'm saying, chairperson, that it was because it was widely reported, our interviews, where he was asked questions about his security clearance, citizenship, how he came into the country. So those were the issues which were deliberated. It's not me.
Okay. All right. Now I think that puts it into perspective. And you're saying even then the whole issue was magnified because
Exactly.
after all, you were a spy, quote unquote.
Thank you.
Okay.
We'll pause there
Thank you, Chair.
and take a 10-minute tea break. Back 5 to 12. Thank you.
Thanks.
Recording stopped.
Welcome back from tea, colleagues and everybody. We turn back over to you, Advocate Mbofu, to proceed.
All right, thank you, Chair. PP, I wanted to just round off that issue we were dealing with and take it to paragraph 91. Table, page 40 or 536. I'll just ask you to read it out, PP. It covers some of the points you just made now, and if you need to comment at the end, just comment. Paragraph 91. This would have been the occasion where within 3 or 4 days of your assumption of office, you were already on the firing line. Yeah. Okay.
Yes, as indicated herein above, Prof. Madonsela left the institution without having presented the 2015-16 annual report to the Portfolio Committee for Justice and Correctional Services. As a result, I had to be the one who presented the scroll up.
Scroll up or down
It's page what?
to 537.
Let me just read myself here. Okay, I was the aforesaid annual report, and I was blamed for using external donor funding. And I was informed by Dr. Mutsaha that there is nothing such as free lunch. The issue of the then Deputy Public Protector, Mr. Kevin Malunga's security clearance was also sharply raised, which cautioned me about his involvement in dealing with classified information in any manner, which could be in breach of the applicable regulations. So that's the origins, Chairperson, and I have indicated that that was the criticism which I received, especially from the mainstream media, because I was said to be, there were articles saying Busi hates Tuli. I think some organizations, is NGOs, is it AfriForum or whatever, saying, why do I have to criticize? And I was blamed as if even from the donors that it's like it's me who stopped everything. But then, you know, being a person who's also not having received any expectations from kind of my employer, I thought, because in terms of the Public Protector Act, I'm accountable to Parliament and especially the Portfolio Committee. Those are the expectations which they have of me. So I took it that I needed to act and make sure that I deal with those. But then again, being security conscious myself and understanding how we should as a country protect our sovereignty and what are the weaknesses which will be there in the system, I had to make sure that I am compliant. And I mean, surely even the Auditor General, when they audit, they would check what policies government is having. Are we as an institution also compliant? So thank you.
Yes. All right. Thank you. All right. So that's the end of that. In fact, I was then saying then you, apart from that special presentation where you are not presenting your own work, for the following years up to now, you are then routinely presenting to the Portfolio Committee your own annual achievements, goals for the next year, and so on, against the Vision 2023, correct?
That is correct, Chairperson. That's what I did. And we tried with the office, because there is something I would request Chairperson that we just reflect on or show. It summarizes the achievements for, I think, 4 or
But that-
5 years. Yes.
That's where we're going now.
Mm.
So if you go to page 231 of your statement.
It's what page?
231, oh, sorry, page 90, Chapo, or 586. Yeah, and yeah, so to close off then this part, you've told us the vision, told us the pillars of the vision, told us the annual road towards the achievement of that vision. And then here you call it main achievements in summary. And if you can read it out.
Yes.
Paragraph 231.
Okay, I'm straining my eyes when I'm going there. As as at the time of my illegal suspension, the institution had released a pie chart attached as Annexure B M13, which reflected, among others, the following key performance areas. So it deals with the audits, where the first public protector to receive 3 clean audits since the establishment of the institution.
Mhm.
The investigation reports, which we have managed to issue, because as the public protector, I don't know, Chairperson, if we can just show that pie chart.
Yeah, no, we will.
I wanted, yes, okay.
You can
Public
proceed.
education activities we've conducted, reports successfully defended in courts versus set aside and reviewed, finalized cases, and the caseload. So that's where the achievements are reflected. And
Right, okay.
yes.
Okay. Tsepo, can we then go to BM 13, which is referred to there? And again, Chairperson, the issue here is really just to give perspective. Because as I said, sometimes we get all bamboozled by the so-called high profile cases and lose the bigger picture. Right, can you bring it up?
Yes.
Or down?
Yeah.
Yeah.
So this was when we haven't received the third
Sorry,
clean audit.
I'm sorry,
Yeah.
PP, to interrupt. Just because I suppose it can't all fit in there. Can you bring it further, just slightly down? Or just show the heading and then you can hide it again. Yeah. It's a public protector in numbers October 2016 to February 2022, which Chairperson would be 2 or 3 months before the suspension. Yeah. So that's it. It's that period. Okay. You can go down. Yeah. Okay. Please take us through.
And by then we still awaiting the audit of that financial year. So before it was 2, so it should be 3 after we've updated. So, and then
Where the 2, you mean under clean audits? Yeah.
yes, clean audits now is 3. And the reports which were issued, investigation reports, so they are 412. By then it was 412. It would be more because I had already adopted a situation where every month at least we will issue reports, and the intention was it's a public education, because when we issue reports, we publish those reports, we inform the media so that people can continuously know what we are doing, because it's part of your outreach process. but I understand that has been stopped. And then out of that, we had 2,372 total public education activities. So this was, then it's your outreach, which was conducted. But then as I indicated, and as we'll deal with in detail in details under the issues of staff related issues, that we had to, and even in my statement is there, we had to restructure the outreach process, because in the past you would find that an outreach officer will say, I am just seeing 5-10 people recorded as an outreach. And then we had to restructure that into a district model at the advice of Ms. Mutsitsi, because she was from Department of Home Affairs, and she was they were doing that model as the provincial rep of Home Affairs in Limpopo. So that was a good way of reaching bigger communities, especially the district model, that in each region, if we have like KZN 11 districts, then if we visit each district, at least we cover a number of local municipalities, and where the issue of agreements, which I've mentioned up there in the MOU, we then collaborate with you if they've got imbizos, the provinces. So we also go there, public education, work with the speakers in their public participation process. So that's what this entails.
Yes.
Then
Sorry,
reports.
just on that, yeah. Is it, you might have mentioned this before, but before your time, to your knowledge, was there ever these innovations, were they already there? The don't know what to call it, suggestion boxes, or the community places where they could drop complaints or whatever at the traditional leaders' premises, as well as the app that you spoke about.
It was not there. Hence, I'm saying that before it was community. In fact, it was outreach. The outreach officials in each province, organizing themselves as the public protector officials. The number of reach was kind of limited, so we had to then rearrange this process for a bigger reach. And I think this chairperson, it's very critical for me to take the public through yourself, through you, because it also goes directly to the issue of incompetence. You know, it deals with what I have done for the greater community. Repeating the issue of the app, and I also have to acknowledge Professor Andre Kit from Northern Cape, who was saying, you know, PP now, fourth industrial revolution, you know, there are many ways for you to be accessible, and which is a brilliant idea. It was just dropped and we ran with it. I mean, this is huge if it's taken seriously, because it means in each house in South Africa where they have at least a smartphone, how many number of people are on Facebook, on Twitter? And if you have this app, which is free, you download it, you have a public protector with you in your gadget. So this is something which I was so excited about. And I think I was even preparing to launch the app before my suspension, because I was saying, this is something which the member of the, but at least this forum and my statement, go out there, download the app. It will be helpful, irrespective of whether you illiterate, you are educated, you are not educated, but then this app will help you because you have this gadget or advice in your house.
Yeah. Thank
So,
you,
yeah.
Chair. That's what's called an ad break. So we should have had the number where to dial at this point, but we'll find it.
I hope it's there in the public protector website. So, and or even they can even go to our Twitter page or Facebook page. It was I think it was uploaded. If not, possibly we will also find a way of sharing it. So reports successfully defended in court. By then it was 9. So the story that the public protector is losing each and every case is not true. There are reports which we have successfully defended, and here as well, the courts have found in our favor, and especially the issues of costs, which some of them we will deal with, and institutions were expected to pay back the cost to the to Public Protector South Africa. Then by then, reports which were reviewed and set aside by the courts were 17. And that compared that number, 17, to the 412 reports which we've issued by then. So ask yourself the percentage which we've lost cases, and I'm labeled this person who is incompetent, who doesn't know the law. And these are the number of reports we've issued. And I'm only mentioning this because these are the reports which reach my desk, and I sign them. They go through the process of a Section 79 notice, a process of reports. So by then, we had a total caseload of 60,962.
Sorry, just to interrupt for the record, the 17 reports out of 412 is 0.04%.
Yes.
There you are.
So
not even 1%.
It's that's correct statistically, but those reports are in different categories as they work.
Yes, so are the ones
there's
that are
governance, there's this.
no, true.
Entire picture.
True, Chairperson.
Thank you.
But so are the ones that were in the 17. Thank you.
Please proceed.
yes, is correct. Chairperson is various reports, but again, it's trying to educate the media that this institution is not only investigating the president, the ministers, but this is 90, how many, 90, yeah. So out of those 60,962 by then, in February 2022, were the total caseload. And then the total finalized was this 58,964. And this is very critical for members of the public out there, because when they say public protector, they think of, well, now, Mkhwebane, which is humanly impossible for me to have done this great work. This is to the credit of each and every staff of the public protector. I said we've got 19, in fact, it's 18 offices now. Each and every investigator who's working, this is how they assisted. Besides investigators, even the support staff, because if it was not for them, we wouldn't have managed to do this. This great work was also done by our communication section, which compiled this with assistance of strategy and everyone. So this is what the impact of this office to the communities out there. But then there could be more which we can do, and there could be more for government to capitalize on this institution and to reach out to the communities, or as well to use us to support you and strengthen you, because that's all what we are intending to, or we are there for.
Yes, thank you. Just so that I can beat the chairperson in the statistics game. That achievement of 58,964 out of 6962 is 97%, chairperson, of achievement, which I think deserves a round of applause. I'm sure people at home are applauding.
Thank you.
Thank you. Well done. Thank you. All right. All right. Now, so overall on the achievements, and basically how you would like the South Africa really to assess you as a public protector. I think that Mr. van der Merwe, if I'm not mistaken,
yes,
and others did say that he has been there from the very beginning and has been with all the other public protectors. And he has never seen the backlog at such low levels as by the time when you were suspended. We don't know what it is like now.
That's true, because the intention, chairperson, is that Remember, the public protector in terms of the constitution is there to investigate improper conduct in state affairs. The additional powers of the public protector is to investigate under the Public Protector Act. And one of the key issues is maladministration. And one of the elements in maladministration is undue delay. Therefore, as an institution, we cannot be an institution where members of the public, they come to us, they complain. We are the ones who are subjecting to the very same issue. So it goes back to the issue that working with the team, putting a lot of pressure, putting a lot of emphasis to them that we cannot be seen to be also subjecting the public to the very same thing which public servants are subjecting them to. Hence, then the pressured environment to deal with the backlog and not to be accused to be subjecting the people to the same maladministration.
Thank you. Yes, okay, that's important. We'll touch on that. I think against that background, Chairperson, when we deal with the so-called HR issues on audit letters and backlog deadlines and so on. Thank you very much.
Thank you.
I think that puts it into perspective. So now, can we move then to the next big topic? Thank you, Chairperson, for allowing that.
Thank you. As you move to the next big topic, one member has consistently been from the very start been raising what you've just covered. Unfortunately, he's not here to hear this, Honorable Olomisa.
Yeah.
Oh, yes.
Consistent to be raising that.
Yeah, that's correct, Chair. Yeah,
I will brief him.
yes,
no problem.
we'll have to brief him. Yes, because
Proceed.
yes, from day one, we were saying,
Yes.
has the public protector not won
Yeah.
any cases?
Yeah.
Yeah, thank you, Chair. Right now, PP, we're going to move into another. Unfortunately, coming back from the grassroots, where we've just detoured now, we go back to the world of the high and mighty. So we're going to go to the next big report that features in your in your inquiry, which is known by various names, but more appropriately, well, at least on this side of the table, we call it the so-called rogue unit. But you know what I'm talking about. Is I think the proper name, Chair, is it's called the Report on an Investigation into Allegations of Violations of the Executive Ethics Code by Mr. Pravin Gordhan, MP, as well as allegations of maladministration, corruption, and improper conduct by the South African Revenue Services. And that's the long name of what we will call the so-called rogue unit report, or the unit, or whatever. Right. Now, I think without much elaboration, you will agree that this is probably, of all your reports, shall we say, this and the Pillay matter, which is related to it, probably were the most litigated and or contested reports in your tenure. Agreed?
That is correct.
Yes. Just from my own experience, I'm thinking that this report, it's gone in various guises to the lower courts, some of the aspects went to the full court, it went to the Constitutional Court and back. Some of the offshoots were the interim orders, and then of course the full court matters, including the bench, the Bakwache bench, and in this matter, and then the Kubushi, I think, bench in the Pillay matter. But all these matters were involving essentially the same players. Minister Gordhan, Mr. Pillay, Mr. Mahashula and a few others, correct?
That is correct.
Right. Now, I would like us, because of that web of litigation, some of these thousands of pages that we had, I think around these issues, according to the independent panel, I think ran into something like 5,000 or 6,000 pages. Just this cluster, which was almost half or just more than half of the 11,000 where we started with before we even opened our mouth in this inquiry. So that's really the general background. Okay, no, so let's go to it now step by step.
Okay.
Maybe we start even before you come in. We've had evidence, and I just want to confirm that you are aware of this, from Ms. Mkhwebane in particular, that even before your time, somewhere I think 2014 or so, there had been a complaint, a related complaint confined to the HR issues, let's call it that, around this so-called rogue unit, correct?
That is correct. It's covered in the report, actually.
It's also covered as part of the background there.
In the report, yes.
Yes. And also just to get one issue out of the way, and this is more relevant, Chair, to one of the accusations about where again the public protector is accused of inventing something. You'll remember that there are allegations that you were going around calling this unit the rogue unit even before you could issue a report. In other words, suggesting that you were preempting the outcome. But we will show later that I think it's Mr. van Lochenberg, ironically, in one of his affidavits, actually tells us where that term came from, which was 2014 from the Sunday Times, I think, when the story erupted. Are you also aware of that?
Correct. I'm aware of that.
Right.
And
as
the
I
wrong
said,
accusations.
yes. And I think I said to one of the witnesses at that time, you were in China minding your own business, not even dreaming that you'd be a public protector.
Correct. My name was Meng Shi in China.
Your name was?
Meng Shi.
Meng Shi. Yeah, well, that will be the Chinese lessons for the chairperson. Yeah. We won't ask what the name meant. All right. Now, okay, fine. Then you do become the public protector 2 years later. And please take us then to the beginning, which is one day you're sitting in your office, just trying to check what that one day is. 12th October 2018. Then there's a complaint by Mr. Floyd Shivambu of the Economic Freedom Fighters, Deputy President and Chief Whip. And then there were also other anonymous complainants. What, in a nutshell, were the issues? If you, Chair, as I'm asking these questions, I think we'll then travel through the report. Seppo, you can then take us to page 4219.
4219 of which report?
Of the rogue unit report, so-called. I did ask for her to prime it before tea. Yes. Okay, or whatever, because I think it is one of those that features in different places. So maybe this is, my numbering might not be. Let's just go to that report and I'll adjust to the numbering as we go along.
Advocate Paul, for record numbering purposes, the report I think is at 3 different places.
Yes.
That's
Fine.
why you, that's how you
I'm
come.
happy to go along with whichever
So
Tsepo is happy with.
can I then suggest she uses the one that's attached to the full record, which would be bundle E,
Mhm.
um, number 4,
Number 4,
and it would be page 216.
216. Okay, fine. We'll do the adjustments. So what I'll do then, Tsepo, for the purposes of this exercise, I'll refer you to the typed. So use that one, but I'll refer you to the typed page numbers. Then. So that will then be page 3 of the report.
Yeah. Sorry, Advocate Mbovu, let me give that reference correct. It's
Mhm.
bundle E,
E.
it's number 7,
Mhm.
and it would be item number 4, page 216. It's the
Item.
one that would be attached to Minister Godin's founding affidavit in the record that you have. Okay.
Okay, good. Thank you. So, Tsepo, then if we can go to typed page 3. Yeah, okay, so I'll use the typed pages or the, what you call those case line, that's the red one, the case line number, because those ones remain standard. Actually, no, they don't, because, oh yeah, 91 is the cover. Can you go to the next page, which is 93? Okay, I'm sorry, Chair, for standardization, let me not move from different, otherwise it's going to be confusing the record. I'll use the typed page numbers here. Okay, so it's page 3. Right. Tsepo, what do you prefer? Maybe I should ask you. Look, I can use the other, you see those other smaller numbers, 87. I can use those if that. I think let's use the report page numbers, because then it won't matter where a member might be looking at it from another document. Yeah. Oh, okay, fine. Okay. Page 3. Roman 3. Yeah. Okay. PP, it says the first complaint was lodged in my office on 12 October 2018 by an anonymous whistleblower. The second complaint was lodged on 9 November 2018 with my office by Mr. Floyd Chibambu of the EFF, Deputy President and Chief Whip. And the complainants were that, and then you list 14 different complaints. So this was quite a comprehensive set of complaints. Maybe, Chair, if you, I'd like us to go through all of them. I know it's a long list. Fortunately, they were cut at some stage, so we want, but just to give the landscape, can you go through?
Yes, thank you. Chairperson, the complaints the complaint which was lodged by Mr. Shivambu, and then the follow-up or the whistleblower as well are as follows. So 1, well, it's in the executive summary, that the former Commissioner of SARS, Mr. Ivan Pillay, failed to follow proper recruitment procedures in the appointment of Mr. Yolise Peki and Mr. Johan van Locherenbeek. 2, Mr. van Locherenbeek unlawfully received cash deposits paid directly into his personal FNB bank account from taxpayers and or representatives under investigation by SARS during 19 November 2012 and 28 May 2014. 3, Mr. Jonas Makwakwa unlawfully received cash deposits into his personal bank account from taxpayers and or representatives under investigation by SARS. Number 4, during the tenure of the former Commissioner of SARS, Mr. Pravin Gordhan, MP, Mr. Gordhan or SARS established an intelligence unit in violation of the South African intelligence prescripts The intelligence unit was confirmed by a SARS investigation report compiled by Advocate Skakan.
Mhm.
5, SARS violated Section 41(1)(e) of the Constitution by not respecting the constitutional status, power, and functions of the National Intelligence Agency.
Mhm.
So I think they mean the SSA currently. So number 6, SARS irregularly procured intelligence equipment, which the intelligence unit utilized for gathering intelligence. 7, SARS fails to follow proper recruitment processes in appointing employees who worked for the intelligence unit.
Mhm.
8, the SARS intelligence unit irregularly backed the offices of the National Prosecuting Authority, NPA, and the Directorate of Special Operations. Next one, SARS, based on an instruction from Mr. Godan, as the former Minister of Finance in 2012, pursued the tax affairs of the current Economic Freedom Fighters President, Mr. Julius Malema, MP, without a legal basis. Next one, Mr. Pillay was appointed to the position of the Deputy SARS Commissioner and subsequently as SARS Commissioner, whilst he did not possess the necessary qualifications for the positions. SARS failed to follow correct procurement processes in the appointment of Accenture. SARS irregularly extended the SARS IT tender for 12 years, resulting in fruitless and wasteful expenditure that has escalated to 8 billion to date. By then, that's what they said. So these are still allegations. That SARS purchased an IT company by the name of Interfront at an amount of 72 million, whilst the company was worth 2 million at the time of purchase. Next one, that Mr. Godan violated the Executive Ethics Code by deliberately misleading the National Assembly in failing to disclose that he had met with a member of the Gupta family since taking office.
Right. Thank you. So those 2% then were the 14 complaints combined. You notice by now we are all familiar now with some of the landscape that there was the EMEA complaint, which is almost similar to the CR17 complaint about the allegations of misleading. And you might also you noticed to relief chair that's again, that confusion about the 2007 code doesn't feature here because the complaint is already worded as deliberately misleading the National Assembly. Okay, thank you. Then again, to all our relief, you made a decision to then slash these 14 items into 2 chunks, so-called part 1 investigation and part 2. And okay, I won't ask you to read them again. Chair, if we go to 4221. Against Roman 5.
4221, that's the number.
Oh, I'm so sorry. I'm confusing typo because I'm now using it. I'm not following my own rule here. Page 5. Typed page 5. Yeah. Against Roman 5. Yeah. Right. So, Chair, if I can just use shorthand, this is quite important. So the issues that were then isolated, and the public protector will tell us why. I'm just using them because so that we don't give the long description every time we talk about them. The first one, Chair, is the EMEA issue, which we'll call the Gupta's issue or misleading of Parliament, or the EMEA issue, as I've just said. The next one deals with the what we call the establishment issue. And it's important to isolate these issues. In other words, this deals strictly with the issue of the establishment of the unit, apart from its activities or whatever. Yeah. And then number 3, we call that the procurement issue. And that deals with the procurement procedures. It's the allegations that SARS failed to follow correct procurement procedures when procuring intelligence equipment, which intelligence unit utilized for gathering intelligence. Okay. Anyone who's ever worked in the PFMA environment like me will tell you that that's bread and butter. You know, how did you procure this? When did you procure it? And so on. Yeah. Okay. And then the 4th issue, we call it the recruitment issue, Chair. And that deals with whether the people who are working for the unit were properly employed as SARS employees. And then the 5th issue, we call it the operations issue. That's now dealing with the actual activities, core activities of the unit, as to whether they were rogue or not rogue. And really, I think the rogueness, quote unquote, really relates only to that issue. And then the last issue is what we call the qualifications issue, Chair. And that's the whole thing about matric certificate and Mr. Pillay being employed as the Deputy SARS Commissioner. Now, you then separated out the other 1, 2, 3, 4, 5, 6, 7 issues on the next page. So we won't go through those. Okay, let me ask you 2 things then about the separation. A, what motivated the separation? And or in other words, what was the logic of the separation? And or what was the relationship between those 6 issues that made up part 1? Can you assist the committee?
Thank you, Chairperson. I think it is very critical. I hope we will deal with okay, maybe let me say from the beginning, the first part of the investigation was dealt with, and we had to split the issues based on the fact that there is an EMIA complaint, which needed to be investigated within 30 days, which is most of the time very difficult to do that, but one strives to come up with various strategies to deal with these matters expediently, because once lodged,
Expeditiously, you are being like Dr.
expeditiously.
Yeah.
Not Masinya. Yes.
Singis.
Yes. So that was the main aim and intention. But I would want you, as that Chairperson, that we go to the ones we didn't investigate, because they deal directly with Mr. Van Logerenbeck, the one who's also one of the witnesses and who's also accusing me of not
consulting.
Yes, so I think that will be critical. But then the intention of doing that is because it's an EMIA complaint. And I indicated yesterday that that was also done by my predecessor. Well, it was not involving EMIA, but then he had her own intentions that derailed a report, the PRASA investigation. So that is what, as the leader and taking those strategic decisions, but also because you'd want to strive to make sure that matters are dealt with quicker. And I didn't want a situation where we get used to the issue that anyway, we can't finalize this report within 30 days. Because normally I would say to the team leadership, you know, one day the Auditor General will be very strict to and be stringent and want us to even account on the issue of performance, because normally now they are focusing more on how the issues of procurement, irregular, unauthorized, wasteful expenditure. But then if they come, they do performance, but not that much.
Mm.
But if they were going to be very strict and also checking the compliance to various legislations, as Advocate Ms. Madonsela said, that they also then were the ones to say, but you are a constitutional institution. You are obligated to also comply to the chapter 12 of the Constitution. You need to have a security policy. You need to comply to the government policy of MIS, therefore comply. When they come to us one day and say, Public Protector, there's the law. You are the sole agency who's investigating stated days. You don't do that. So hence that motivation of splitting these issues into 6, and then the remaining, they were dealt with as part 2 of the investigation. So that's what motivated me to do that. And I think in any investigation, I said it yesterday that, for instance, the delay to investigate, sometimes you'll find yourself having to look into all other issues. Because I said, when we issue a letter of document request, you'd find that we include each and everything. I think you've seen yesterday when I was dealing with the Pala matter, that will include your tax evasion, those allegations. Because when we receive the information, then that's where you'll decide, this one still needs a lot of follow-up. It will take maybe longer. Then that's where as a Public Protector will decide, because possibly even in this one, I would have decided, let me separate the two. The other matters which needs follow-up and getting any other information, let's deal with it as part 2. This one, let's deal it with part 1. And again, for the sake of the person who's being accused, because you don't want something to be hanging over the head. You want as well to dispense with the matter as quickly as possible. So that was the main intention.
Yes, thank you. And as we know, and I think in all the reports that we're going to deal with, which are the so-called high-profile matters, there would always be, shall we say, I think public pressure. I think Mr. Chiwalule, all of even Mr. Kekana, Mr. Samuel, and all the people who are involved in all those high-profile matters would say that the public, understandably, would want to get quick answers. And you've just mentioned the Pala matter, CR17, just because of they are topical matters. And even if the 30 days is not achievable, as you say, it's incumbent upon you as a leader to find ways to minimize the period.
Correct.
Yes, thank you. And I think that also, without going back to yesterday's evidence, relates to the issue where the chairperson said I was giving you a compliment about the speed with which you acted in the of the complaint from Mr. Zungula. So that was generally the motivation. Okay, now if maybe taking that example, why did you not split like this, a matter like that?
Hence, I'm saying that, unfortunately, remember, I sent those 31 questions. It was going to be the decision for one to then deal with decide. Do we delay? Do we wait for all the conduct the forensic evidence, go to SARS, go to any other institution possibly, and collate the evidence? So that was not done because it was going to be exactly quicker, because if that was the intention also to dispense with a violation possibly of Section 96 of the Constitution or violation of the Executive Members Ethics Act, then would separate that, and especially after the acknowledgement or the statements which the president made about, yes, I'm trading in this, I'm dealing with this. So those are the concessions which would then say, okay, let's deal with that and be over and done with. Then possibly the forensic investigation, we deal with it later. So as we have done in the past, and it was purely based on the fact of compliance and dealing with matters speedily.
All right. Okay, now then, all right, so now the split is now done. And I've given the shorthand to the chairperson about the 6 matters that you did isolate. And I think what you wanted to highlight of the matters that you did not do was an issue which I've raised with Ms. Mkhwebane and I think to some extent Mr. van Lochenberg, because you remember Mr. van Lochenberg's big gripe is that he was not given Section 7(9), he was not given a right to be heard and all that. Did Mr. van Lochenberg feature anywhere in the 6 issues that were formed part 1 of the investigation as an implicated person?
That's where we're going back to the issue of the 6 items. Firstly, Mr. Godan, the fast tracking of the EMIA. Secondly, Mr. Godan as the SARS commissioner, as the accounting officer, establishing the unit. Thirdly, the recruitment processes, the issue of the operations and the appointment of Mr. Pillay. Is the issue of qualifications, because I think that one, people must just put it, or the chairperson and members of the committee, just see how we've structured the issue, what we were investigating. We were not investigating the metric certificate or metric. We were investigating the qualification. Now, hence the issue of serving Mr. Godan, Mr. Pillay with the, because they were implicated parties. At some stage, they were accounting officers. At some stage, they were at executive management level. Mr. van Lochenberg was not at this stage, part A, implicated, because we were going to interview, deal with him, serve him with the Section 7(9) if there's any implication on him when we do the 2nd volume of the investigation. That's where you find him being directly mentioned, where he benefited directly, apparently.
Sepo, can you go
Yes.
to page 6, please? Sorry, Pipi. Okay, so this, go further down. Yeah. All right, so these were the, you're saying he featured in the issues which were separated out, and you can see his name, I think, in 2 parts, A and B. And I think for perspective, we should also include C. All right, can you then explain in the first time when his name appears, allegation that issues relating to Commissioner of SARS, Mr. Evan Pillay, failing to follow proper recruitment procedures in the appointment of Mr. Yolise Pike and Mr. Johan van Lochenberg. In that issue, did Mr. van Lochenberg feature as an implicated party?
In this instance, remember we are investigating the former SARS commissioner, Mr. Evan Pillay. But the appointment relating to, as the decision maker, Mr. Pillay, how he was supposed to follow process when he appoints these 2. Maybe to simplify in this matter, the appointment, a public servant, you can't be punished that the person or the employer didn't follow the process, or as an institution, we are investigating the decision maker. So here, the person was supposed to account. The example I gave yesterday of a municipal manager who appoints somebody who doesn't qualify, because we will have to deal with the accounting officer, the municipal manager. We cannot serve Section 7(9) to this particular person who applied and they didn't follow their process and was appointed. So normally when we investigate, we deal with this accounting improper conduct of the decision maker. So in this instance, that's what transpired, because For instance, this issue, we said, let's defer it. And when we were going to deal with this, we were going to expect answers from Mr. Ivan Pillay, because that's where we will then say, did you advertise the position? When you were appointing Mr. Becky and Van Locherenbeck, where are their CVs? Where is the panel which set and determine the appointment of this? What is your policy saying about that? Because you should have done job evaluation, we call it JE. You should have indicated that at this position, if we're appointing you at this position, you should have a degree or qualification or so much experience.
Right.
So that's what was expected in this particular instance. And even in point 1A, a lot of engagement was going to be with Mr. Ivan Pillay on this one.
Yes, but so was Mr. Van Locherenbeck then an implicated party in A?
He's an affected party, he's not an implicated party.
Thank you. Okay. Then,
Because he never appointed himself.
yes.
Back there.
Well,
Yeah,
back there.
now we're getting there.
Yeah.
Thank you.
All right.
Oh, yes.
Yeah. All right. So, okay, and you've explained why he's not like your matriculous person in some municipality. All right. Now, let's go to B, just maybe so that the chairperson's question of yesterday is
It's answered.
somewhat answered. Yeah.
Thanks.
There now it says the allegation that Mr. Van Locherenbeck, so is now about him, unlawfully received cash deposits paid directly into his personal FNB account from taxpayers, representatives, under investigation by SARS during 19 November 2022 and 20 May 2014. And as far as this allegation is concerned, was Mr. Van Locherenbeck an implicated party?
Is an implicated party here.
All right.
Here we were supposed then to deal directly with him, issue him with that letter, document request,
Yes.
questions, everything, because then that's a first out.
Yes.
Yeah.
Good. And I said we'll read C just for perspective, Chair. You'll see that almost word for word, that allegation is now repeated against Mr. Mkhwebane. So the allegation that Mr. Jonas Mkhwebane unlawfully received cash deposits into his personal account from taxpayers and or representatives under investigation by SARS. So who was the implicated party?
Mr. Mkhwebane,
Yes.
same as Mr. Van Locherenbeck. So he was supposed to also be contacted, served with letter, be interviewed and everything, be given that opportunity. So he was going to be an implicated party if we find any improper conduct.
Yes, but the question is both Mr. Mkhwebane and Mr. Van Locherenbeck, then you say they would have deserved to be contacted and so on as implicated parties in relation to B and C.
As
But
implicated
would that,
party.
yes, but would that be in part A or part, what you call it, volume 1 or the second volume of the investigation?
The second volume.
Okay, thank you. I think that's 80% to answering the chairperson. It's question of yesterday. All right. Now let's then go back to volume 1 or part 1 or whatever of the investigation. So now we know who the complainants are, we know what the issues are, we know who the implicated people are and who the implicated people are not. So then what then happens next? And Chair, I'm doing this also in a way to use this case as a case study, as it were, like we did yesterday. So I almost got into trouble because I was using a different case study. Now we're using this particular report also just, and we won't do it again when we get to CX or Fred, just to see how these things actually flow into being. That's why I started from day 1 when she receives the complaint, and day 2, quote unquote, where she then separates them out. So notionally, then we're in day 3, if you know what I mean, PP. What then happens next? You've received the complaint, you've separated it out, you've told us the logic of the separation, and now what did you do next?
Then the critical issue as well for the public to know is that in an institution, the complaint is lodged, a file has been opened. I am no way analyzing, assessing, and doing all this. But the issue is when an EMIA is lodged, that's where automatically they know I must be informed if the complaint has not been sent directly to my office. So after that, the file was allocated then to the investigators. We've heard Mr. Mataboge was the chief investigator. Bianca was the investigator dealing with this particular matter. So they are the ones who are then conducting the investigation. Firstly, they would issue a document request letter. Then that, because it involves the minister and it falls under Executive Members Ethics Act, it's sent directly to me, and they prepare a submission where Mr. Mataboge will sign. It goes to the executive manager, to the chief operating officer if he's there. Then it lands in my desk, and then I go through. If I pick up maybe somewhere which they need to change and improve, that's where, or maybe they advise, okay, let's split these issues, let's deal with this. Then I sign the letter, then it's sent to the implicated party.
Okay, good. And I think Ms. Mkhwebane then told us that one of the first things that they do then, once they are, those kinds of people are now part of the team, as it were, once they've been allocated, is to contact the complainant, basically to streamline the complaint. And so again, I want to know, do you get involved in that process, or is it now done by the rest of the members of the team who are in charge of this?
Generally, it's done by the investigator, and that is compulsory as well, trying to instill the issue of dealing with matters quicker, but as well avoid the Friday issue, which we'll deal with. We call it in the ombudsmanship, the issue creeping, you know, because when a complaint like this is lodged, the complainant will have to sit down with the complainant. It helps, or even call the complainant. We received your complaint. You are raising the following issues. This is our mandate. You want us to investigate A, B, C, and D. And then we lock the issues. So I advise them do that. And there is a service standard document which we've developed to say, when you receive a complaint, within so many days, contact the complainant. Understand what are the issues you're going to investigate. When you prepare that letter to the implicated party, already you know what issues. And also, we normally say to the complainant, help us, give us any documentation which it's in your possession, which we can also have so that we understand exactly what your complaint is. That helps with the issue creeping. Let's put it at the back of our mind for the Friday investigation. How does it complicate issues when you have moved to such an extent that the investigation is almost at the end? Then there's another issue which is raised, which you've spent so many years. Now you must start afresh. So when a complaint is lodged, they are the ones who receive, meet the complainant. After that, they would then assess with the supervisor how complicated the matter is. Because sometimes a complaint can be lodged and they will think, for instance, sorry, Chairperson, to just digress. A person complaining, I am a delay. Home Affairs is delaying to give me an ID. You see, simple, should be a call away, or Home Affairs here's this person.
It's a real serious example.
Yes.
I think the
Yes. And
chairperson
then
is
the
still
next
waiting
thing,
for his ID.
yes. Then the next thing, the investigator engaged this person,
Mm.
rise to Home Affairs. You are violating undue delay. You should be taking 14 days to issue an ID. Then boom, the person is naturalized, or the birth was never reported on time. Home Affairs, the application is made, but they are still conducting an investigation. Sometimes they take up to 6 months to do that, or even a year. So the main issue to meet with the complainant is directly to make sure that we log issues.
Mm.
Then that will also help the investigator, not me. I'm nowhere near to prepare an investigation plan.
Ah,
And the investigation plan is guided by the fact that they know each one of them per our strategic document, but they also know that when it is a kind of early resolution matter, the simple or the matter, it's very critical indeed, but the one we will say it's just the call away, the Home Affairs, early resolution, which we gave ourselves 6 months to also incorporate the delays and maybe the complication. Then we've got the service delivery related complaints where we deal with a service failure. And then we've got the conduct failure complaints, which are under good governance and integrity. That's where Bomvuyane and Mataboge are. So that's them who decide. I'm nowhere there because as leadership, accounting officer and executive authority have designed a strategy, they need to feed into that particular strategy. Now they draft an investigation plan. They've assessed the matter. It doesn't fall, this one doesn't fall under service failures. Service failures, we take up to 12 months. This one is a good governance and integrity. It takes up to 24 months. And EMIA is 30 days. So that investigation plan then should incorporate all those timeframes for us to be accountable to Parliament, to say, Parliament, we committed in our strategy, we will be doing GGI matters within 24 months. And indeed, women. So they draft their own investigation plan, which will then count back. Because if it's a matter like a 2-year matter, they should then plot the dates that meet with the complainant, send the document request letter to the department or to Mr. Kodan, give him 14 to 20 days or 30 days according to the service standards, which will have to comply with the rules of the public protector. Then if he doesn't respond, firstly, I'm just trying to cover all those nitty-gritty so that when I mention them on all these reports we've already done. Then if they don't respond, we then can issue the first reminder, then the second reminder. That's where we come to the 3-strike rule. If they fail to respond, then we issue a subpoena. But then a subpoena, again, to clarify for members of the committee, I can issue it based on, we will go to that section where the public protector can decide the mode of investigation for dealing with the yes, for dealing with the matter quicker. So that's what transpired. So I'm not there with them. They do that on their own. So for me, when they bring the letter, because it's going to the minister, that's where I sign, go through the documents, send it back to them. They send it. When they prepare for the subpoena, they prepare subpoena for me. They bring to my office because it's going to those individuals, and then I sign. So that's what transpired even in this particular matter.
Okay, thank you. Yes, no, I think that really then should clarify it for everyone. And just, you know, as a former CEO, what you're talking about is now high level management. So the so-called dashboards, the meeting is called dashboard, but actually it should be dashboards because there are different dashboards for the 6 months matters, for the 12 months matters, for the 36 months matters, for the 30 days matters. And as you say, then the managers themselves then populate the deadlines for each matter. So
Actually start with you as an individual,
Mhm.
because when you draft that investigation plan,
Mm.
you are the one who's committing that my project plan or my action plan demands of me to finalize this matter within 24 months,
Mhm.
within 10 days.
Okay. Right. Okay. Then, all right. So that was done, and you had your plan and what have you, and engagements with the complainants. I think Ms. Mkhwebane took us through that. You don't have to take us in any event. You're saying you are not involved at that level. Then once all that is done, what then happens at your level? At what point does the matter come back to you? And by that, I mean, when are you going to meet with this matter again? Will you meet it at, I forgot what your meetings are called, at dashboard or at, what is the other one called?
Task register
Yeah,
meeting.
task register and what have you. Once all those preliminaries are done, when is your next, I'm talking about at your level, your next interaction with this, with a matter like this?
You know, as the public protector, that's why sometimes when you just explain to people, or when we were engaging with the remunerations committee, when they were asking, sorry to digress, Chairperson, they're asking, but what at what level, or you know, as a public protector, what is it expected of you? Because you are an executive authority. And we were giving an example whether the minister is involved in Rule 53, in preparing Rule 53. But again, as a public protector, you find yourself, because the Constitution says public protector, investigate. And the Act says I've delegated those powers. But then when it comes to the issue of EMIA, for instance, in this one, then there's an issue where I would then insist that the task register, which is the weekly process, which I had to say, COO, CEO, well, COO is a chief operating officer for those who don't know, CEO, chief executive officer.
And ACE is acting chief executive, not Ace Mahashu.
Yes, the CE actually, the late Mr. Nyembe, my chief of staff, used to say, instead of saying CEO, would say CE, chief executive, like in SOEs.
Yeah.
So he came with that. Now, when the person who was acting, then we would say ACE. Now we adopted his way of doing things. Yeah. So that's where I engage with matters. That's where I will ask, okay, we've received this complaint because I've signed the letter. I've seen that we have this matter. And it's what we call, which I adopted from my predecessor, special attention matters. Same. So I didn't stop that. I would say I want to know on all these key issues, because those are the matters they'll be in the media. I receive media inquiries. I'm also being criticized or attacked that we are delaying on these, or political parties threatening to take us to court. So I need to be aware. So that this matter was one of those. So it was in the agenda of task register.
Right.
Yes.
Good. And right. So then we'll come back to the process issues, because the chair will now ask me to come back to the rogue unit matter.
Yes.
Yes. I can read it now.
Maybe we're ready for lunch now.
And we're ready.
So when we
Okay,
come
fine.
back to lunch,
Then
we'll
we'll
back
zoom.
to the
Yes.
unit issues.
Thank you, PP.
Thank
I
you.
think that gives us a good
We'll
platform.
take a lunch break, back at 2.
Recording stopped.
Welcome back. We resume the hearing. Back to the unit issues. Going to ask Advocate Mbofu to get into that. I think
Thank you, Chair.
you would have landscaped it already. Thank
Yeah.
you.
Thank you, Chairperson. All right. So if, yeah, for now, let's just go past the what is the exposition of the issues and the approach to the investigation and so on. That you dealt with when you doing your landscaping last week, 2 weeks ago. What happened, what should have happened, and so on. So now
Yes.
we have at 4.3, which is page 30, Tsepo, of the report. 30, 11, small 114 at the top. Yes, that section then says, on analysis of the complaint, the following were the issues considered and investigated. And basically, we don't have to go through that. You then list the issues again. And I take it, I think, from Ms. Mkhwebane that's now after the interaction with the complainant, where you say you lock the issues to avoid issue creep.
That's correct.
Right. And 4.4, can it tell us, there's a list of so many things there, which the key sources of information, and I think we pointed out to one of the witnesses, the word key sources. So it's clearly not intended to be all the documents, but what do you normally include there?
Where we include the documents we have relied on, the correspondence with the various institutions, their responses, their recordings, if we have any recordings which they provide. We also then deal with the section 7(9) notices which were issued to the implicated parties. So the sources of information is what was before us when we were conducting the investigation and what we relied on when we conduct the investigation.
Right.
For instance, if you deal with recruitment, you'll have to have their recruitment policies. If we deal with procurement, we'll have to have their procurement policies, the reports which were there, or any documentation which we received from all the institutions which we have approached.
Right. And this is a question I should ask you later on when we deal with the so-called IGI report. But I think for the sake of, because everyone knows the issue by now, we can raise it now just to flag it. You'll remember that one of the accusations or issues that are raised as a basis for criticism is this suggestion that you at worst is that it says you articulated explicitly, Nochal, that you had not seen the IGI report. I think by now everyone knows that it doesn't, there's nowhere in the report where it says that. But I think a sub theme of that is that, okay, well, maybe you did not articulate it explicitly, but somehow you concealed that fact. Which is not the accusation in the judgment, but it's now a new variation. But let's try and meet even that variation. If just go to 4.4.1.29. No, let's start firstly with 4.4.1.12, page 32.
I think it starts at 4.4.1.6, page
0.6.
31. Yeah.
Okay, that's the letter. Yes, yes. Okay, yes, that's a cluster of letters. I was just going to the last one. You want us to go to the first one?
0.6, the letter to the OIGI.
Yes. Yes, that letter. That's, and then the 0.7 is another letter
Their
to
response, yes,
and 0.8
is the subpoena to the minister.
0.9.
Is the letter from IGI.
Okay.
Again.
Yes. 0.10
is the letter from the acting DG of South African Security Agency.
0.11
is the letter to the Minister of SSA.
and then 0.12.
That's the letter, the response of the minister.
Yes.
So
Now
all these letters are dealing with the issue of
the report.
The report.
Yes. Okay. Now, would anybody reading those letters, given the content of those letters, some of which we have gone through, I think, with Mr. Matabuche, can anyone who has read those documents ever think that you were concealing in this report that you had a report anonymously dropped at your offices, given what is actually written in those letters?
Definitely not. A reasonable person would not think like that.
Just keep the mic closer.
Yes.
A reasonable person will never think like that. And a person who will assess and adjudicate this matter with an open mind will never think like that.
Right. And if anyone really, after reading those letters or referring to them or even understanding what they are, whether that person is a judge or a member of parliament, and they have letters in which some of the letters say, I have a report, or you have a report, please give it to us. And there's a whole fight about it. Would it ever be justifiable to say, actually, you were concealing the fact that you had such a report?
I don't know where that, well, I don't understand why they came to that conclusion, but we're still going to deal with the judgment.
Yes.
Because at the end of the day, being the public protector, receiving all kinds of information, being the public protector, who is a safe haven for whistleblowers, who receive documents from all and sundry, people who are following up on such investigations, who are interested, sending information. Therefore, my responsibility as the public protector was to get the document from the state institution, which is the custodian of this report.
Yes.
So all these letters, they are explaining, they are very clear. The recordings are even indicate that I have this report anonymously dropped. Can you avail the report? Can you confirm you have the report? You know about the report, which was confirmed in the responses.
Yes. And specifically, can I take you then to 4.4.1.29? Just to emphasize that point. 4.4.1.29, that's on page 33. 0.21, yeah. There you disclose that among the key sources of information is recordings relating, no, I'm sorry, further documents blurred and or not listed due to their nature.
Definitely.
Yeah. What among those were you referring to?
I was referring to the very same IGI report. I was referring to the equipments, which to me, I felt for being security conscious and not wanting to expose the country to unnecessary. I mean, these are, well, the allegations or the discussions with IGI, where even the minister was saying, you know, you'll be exposing the individuals or our sources and even our security or our intelligence trades and all those. And it's very clear because the Constitution demands of me when I issue any report, unless there is something which I need to ensure that it's not published, I can then not publish that report because it demands of me to issue a report, but then unless then there are circumstances which I need to take into consideration for the protection of the security of the country or for the protection of the information.
Yes. Yes, sorry, I've just misplaced my act here. Chair, when the time comes, I'll refer to actually there's a reference to this in the Public Protectors Act, and I'll refer the committee to the specific section. Yeah. All right.
Section 8, yeah, and then the Constitution is section 182. 1, yes.
Yes.
The publication of reports.
Yeah. All right. Okay. Yeah, 1821 is the broad one, but
Yeah.
In the Public Protector Act, you're saying section 8, then there's specific
Section
reference
8,
to
yes.
security concerns. I just wanted the actual wording, but it's fine. We'll get to it when at appropriate time. Then under 4.4.2.1, again, you disclose something there. Can you read it out?
4.2.
4.4.2.1.
The correspondence from SARS.
4.4.2.1.
4.2.1. The recordings relating to the operations of the intelligence unit.
Yes. Again, for someone who was concealing or hiding this issue of the possession of the leaked report, what were you talking about there?
There it refers to the information which we received or the evidence which we've received about the said members of the unit who were interviewed by the former commissioner of SARS and who confirmed the operations of the unit and what it was expected to do.
Right. Okay. Now, all right. Okay. Then let's then go to the issues. Paragraph page 35. Oh, sorry. Before to that.
Before
Chair.
35, I think the legislation.
Yes. No, even before the legislation, just a question that might go into the chairperson's issue. You go to 4.4.4. there you list then the people who did receive Section 7.9. You've explained why Mr. Van Lochenberg didn't get it. But so we've got Mr. Pillay that we know is clearly an implicated party, Mr. Mahashula, Mr. Kodan. But at 4.4.4, you have Minister of Finance, Mr. Trevor Manuel, that you served with the 7.9. And to which the chairperson might say, why did you do that if you say Section 7.9 are only for implicated parties? To what extent was he implicated?
Maybe starting from 4.3, those are the people who we've served with the OD, which is a notice, and then they responded. Mr. Manuel, it was because he approved the submission of the memo, which was written by Mr. Kodan when he was the accounting officer at SARS by then. So then he requested approval from the Minister of Finance. So we were giving Mr. Manuel an opportunity to, because he's implicated, he approved the establishment of this unit. Yes.
Okay, good. So because at that stage, Mr. Kodan, at least as far as that particular allegation is concerned, he was not a minister, he was a commissioner for SARS.
Correct.
All right. Okay. Then the legislation, again, I think will tell us a story before we read the report as to what we lawyers call the regulatory framework that governed, against which rather the factual findings would be measured. And if I may, it's the Constitution, the Public Protector Act, South African Revenue Service Act, PFMA, National Treasury Regulations, National Strategic Intelligence Act, Interception of Communications and Provisions of Communication-Related Information Act. That's the mouthful. That's the one that says you can only intercept people's communication if you have a judge, or rather a court order, yes.
Correct.
And then the SARS recruitment and selection policy. Okay. Collectively then, can you explain why, firstly, it's necessary to put those, and what role does that section play?
This role or the section, when you are somebody who's adjudicating our matter before court, you'll see that this is the legislative framework which we checked against the investigation process, what happened, what should have happened, so are the facts, and then whether there's any gaps in whatever should have happened. And remember, the complaint also was saying they violated Section 209 of the Constitution, which addresses the issue of the intelligence, and if it's done by another institution, the president should give a go-ahead on that particular issue. Also, we were showing that the procurement, the violations of the Public Finance Management Act, because we are dealing with accounting officers here, the issue of the SARS Act, we had to check it because we need to understand their operations, the powers of the accounting officer, the role of the minister as well, as far as that is concerned. The National Strategic Intelligence Act, what does it say? So this is what the public protector is all about, like the Auditor General, because we just check whether any improper conduct, is it compliant with the provisions of the laws governing that particular institution. So this was purely that.
Good. All right.
And then the case law also, we referred to this because we relied on them. especially when the responses of the implicated parties or when we investigate, then we need to highlight these cases so that we can rely on them, maybe why we needed to even inform them. We never, our investigations are not subjected to PAJA, our investigations are subjected to legality. Hence, we mentioned the Home Affairs versus the Parent Protector legislation, the SCA judgment.
All right. Okay, just for the sake of flow, can you, obviously, we're not going to go through all those various acts of parliament and so on, and until they become relevant is in our in the evidence. But I think it's important, maybe just for the members, to anchor the rest of this report against the Constitution and the constitutional provision which featured here. Can you just fast forward to page 55, Tsepo? Right. And if you can read out the section 2091 of the Constitution, what it says, and then you'll explain why it was important for this particular report.
Yes. So in terms of section 2091 of the Constitution, any intelligence service other than any intelligence division of the Defense Force or Police Service may be established only by the President as head of the National Executive and only in terms of national legislation. So this is what it means, and this section is very much relevant to our investigation.
So that's, if you like, is the canvas for the entire investigation, that any intelligence service in South Africa, other than intelligence division of the Defense Force, might be established only by the President.
Yes.
So then it becomes a simple exercise, whether whatever it is you are investigating is an intelligence service or not.
Correct.
If it is, then obviously it falls under this section.
Correct.
Okay, good. All right, so that's then the next section is obvious. The Mail and Guardian, Home Affairs, that's just the relevant case law. All right, now let's get to the meat of the report. So the first issue which you dealt with was regarding, it was for the reasons that you've already explained, the EMEA issue, regarding whether Mr. Kodan violated the Executive Ethics Code by deliberately misleading the National Assembly in failing, it's 5.1. Let's just stay with the report because what that's yeah. Thank you. So the big heading is the issues, effectively.
Yes.
And then the first issue that you then tackle is 5.1, regarding whether Mr. Kodan violated the Executive Ethics Code by deliberately misleading the National Assembly in failing to disclose that he had met with a member of the Gupta family since taking office. All right, take us through that, almost assuming this was the only issue for now that you're investigating. What is, we already know it's an EMEA issue, it's important, it's urgent and all that, 30 days, but how do you then tackle that issue so that, again, we don't have to do that for all the other 6 issues? So let's use this as the pilot.
This matter, the investigator will then, starting point, this has no common issues because it means there were disputes only. There was no issue where Mr. Kodan was agreeing to anything, which we've indicated. Hence, they had to put issues in dispute. where he denied the allegation that he lied or misled Parliament.
Mm.
So this will be the first letter which was written to him,
Mhm.
which will then request of him to give us his side of the story. And if that's not the case, sometimes we will then inform the president we are investigating, and then we failed to finalize this matter within 30 30 days. And then we also, when conducting an investigation in this, because EMIA should be the quickest, it's just that sometimes then you'll have to acquire all the evidence, and your investigation should be evidence-based. So we had to get the response, the question from Parliament and his response. And there was then an allegation that when he responded at the Zondo Commission, because he was asked about this, then he remembered that actually he met with Mr. Ambani, the one of the who's linked to the Gupta family and some
And one of the brothers, I
yes.
think, yeah.
So then all this evidence, it's analyzed by the investigator.
Yeah.
Then they have to check what was the question, what was the response, and how he responded. And then is there any gap, or is there any concern that indeed he didn't do what was expected of him? What the Executive Members Ethics Act and Code is saying about that as the minister. So in this particular instance, that's what transpired. So if you go through the report, we are showing what was the question, page 36, 5.1.6.
Six.
And
Okay, where did the question come from?
the question was from Parliament. The member of DA, Mr. Mkhwebane, who asked the Minister of Finance, has he ever met with any member, employee, and or close associate of the Gupta family, and or attended any meeting with the specified persons at the Gupta Saxonwold estate in Johannesburg or anywhere else since taking office? If not, what is the position in this regard? If so, in each specified case, what are the names of the persons who were present at each meeting? When and where did each such meeting take place? And what was the purpose of each specified meeting? Then we got the reply from the records of Parliament where he said, I have not attended any meeting with the Gupta family or anyone else at their Saxonwold estate. I have encountered one or more members of his family at public events on a few occasions, e.g. cricket match. I have met one of the Gupta brothers at Mahlamandlovu around 2009-10, during which a brief discussion on small business finance took place.
Right.
So then we go to the extract from the Zondo Commission.
Okay, just a minute before the Zondo Commission. So because it's here, it now looks like something that might have happened the next day, but I think it's important to show the difference. So that question, which came from Mr. Mkhwebane or whatever, was 11th April 2016.
That's correct.
Yeah. So we can, the answer must have been, we don't have the date, but it would have been somewhere around then.
The answer, yes.
The reply,
I think,
yeah.
I think they have, they are given dates to reply in
yeah.
Parliament.
Yeah, it depends. If it's a written question, it's 10 days
Yes.
thereafter. If it's oral, it's on the day.
On the same day.
Yeah.
Okay. So let's say at West, it would have been still October, November of 2016. I'm sorry, the question was 11th April, May. Yeah. Even given all the holidays and what have you. Okay, thanks. Thank you, Chairperson. Right. And then, so the in October 2018, this is now 2.5 years later, what then happened there?
And there was proceedings before the Commission of Inquiry on State Capture on the
Otherwise
11th of
known as the
October.
Zondo Commission.
Commission,
Mhm.
correct? Where he said, I had forgotten of another instance where one of the Gupta brothers may have been present at the meeting I had with billionaire and Indian businessman Anil Ambani of the Reliance Group of companies in or about June 2010. So I stress that I do not recall the details set out below since it proved to be a meeting of little significance at the time, but have been assisted in this regard by my former chief of staff, Mr. Dondo Mkhwebane.
Okay,
Yes.
all right, I think we get the gist. So
Mm.
2.5 years later, he says at the Zondo Commission now, that answer that I gave in April or May 2016, 2.5 years ago was wrong.
Yes.
And I've been reminded, quote unquote, by the DG. Was this, to your knowledge, ever this correction made to Parliament itself?
According to the information we had during this investigation, it was never made to Parliament. It was only made during this
Zondo Commission.
commission hearings.
Right. And unlike the president, whom at least made his correction, quote unquote, 2 weeks later, this one was made 2.5 years later. And the president made his correction to Parliament, which is where he had made the mistake, according to him. But this one was made somewhere in Braamfontein.
That is correct. Hence, the main issue for us is in such instances, because a person, there's a law, Executive Members Ethics Act, and the code which says they must be truthful to Parliament since they've taken an oath of office. So this is raised at the inquiry at the Zondo Commission. And by then we didn't have any record which shows that they also maybe made corrections. And I think, again, this still shows that Parliament should be considering the amendment of EMIA very seriously.
Yes.
To address and compel people that, okay, if you have not included the information, but you definitely must go back to Parliament and maintain the decorum of Parliament and the respect.
Yes, that's, and possibly within a particular period.
Yes.
Surely not 2 or 3
2
years
years down
later.
the line. Mm.
Okay. And this is the kind of issue that in the CR17 report you were criticized for even making suggestions about those kinds of things, of saying maybe we should look at the rules to make sure that this doesn't happen again.
Correct.
All right. Anyway, that was his story. So his story was that then it's summarized on the following page. Effectively that he had this meeting with Indian businessman, Mr. Ambani, and there was one of the Gupta brothers, but he forgot, and his DG reminded him, and he says there, he does not recall this Gupta person being there, but he may or may not have attended something like that. I think that if you go to 12.3. 123.5.6, Chairperson. So Mr. Mkhwebane has advised me that he recollects that Mr. Ajay Gupta was present at the meeting. I do not recall him being present. I wish to refer to the Commission to annexure whatever, which is my response to a Parliament question from the DA. It appeared in my written response that I do not make mention.
It is apparent.
Yeah, it is, yes, it is apparent in my written response, thanks, Chair, that I do not make mention of the 2010 meeting with Mr. Ambani of the Reliance Group, which a Gupta brother may or may not have attended. This is simply because at the time of this of submitting the written response, I had no recollection of the 2010 meeting with Mr. Ambani. Okay, I can't claim that I understand that, but that was the answer that I don't know which part he recalls, which part he doesn't recall, but that a Gupta brother may or may not have been at that meeting. Now, okay, this parliament now, I'm talking about this committee. What must it make of this? I mean, how do we know what Mr. Kotan was intending to say here?
Maybe let me start by saying, go back to the question. I think again, it's for future lesson, Uguchi, when they respond to questions of parliament, because the question, it says, has he ever met with any member, employee,
5.1.6.
and or?
Hmm.
So close associate of the Gupta family and or attended any meeting with the specified persons at the Gupta Saxon World, 1, anywhere else, 2, and then the other parties, what are the names of those people? So the response was only addressing the Gupta family and anyone else, but at Saxon World, not even mentioning, well, he mentioned that anywhere else, those people he met at a cricket match and Mahlamandlov. So the issue here was, then he recalled that there was a meeting where he met specifically this Gupta associate, and it was not at Saxon World, but yes, it was somewhere else where he met. So the main thing here was that he should have, well, though the rules don't provide, corrected that to parliament, but he just remembered outside of parliament that he met this particular individual. So I think his explanation is that. But then here we were trying to say to him, you either intentionally or inadvertently misled the president, or in fact here in this case, the legislature, because that's what the executive ethics code is saying.
Yes.
Or
Okay.
the 2007, which we were using.
Well, okay, but the way you framed the issue before, it was whether he misled, there was no inadvertently.
Yes.
So, but anyway, in fact, what I was getting at is really, okay, given that Mr. Kotan did not come here, will we ever know what he was trying to say there?
Yes, because he's explaining himself, and hence I'm saying that even his answer to that question, if he was here, he would have clarified further to say, okay, Roman figure 1 says this. What is your answer? Because normally I think that's what they would expect them to answer. But then it was just a lumping everything together, which was supposed to say, on this date, this is what, no member of the family, no meeting with the associate, no meeting at Saxon World, or meeting at, only met at Nahlambandlovu and the cricket match. And this is the particular person. So this was going to help if he was also here to explain to the committee what he meant specifically about that, like general answer to the matter, and then later clarifying to the Zondo Commission. So I don't know whether this committee will be able to make any conclusion based on this if he is also not presenting what he actually meant by this.
Maybe
Okay.
just before
Sorry, Chair.
before you proceed,
Yeah.
just on that question and the gaps that the PP is identifying.
Hmm.
Because I'm not sure if you were able as that institution to follow up with the member, because normally that would have been an answer back to Parliament to that member. And rules do assist that if there are gaps, then there gets to be follow-ups on those if questions have not been fully answered, because that's a requirement of Parliament. So I'm checking
Yes.
if having looked at that answer from your side, whether there would have been a conversation with the member to say, because if the member
Hmm.
has not taken up the issue thereafter, the matter is closed then.
Yes.
So it
That's-
can't be taken by any other
Yes.
external party in that way, in terms of the rules.
Yes.
So just to make, unless the situation that says the member was not happy, was ignored, and all of them, that gets to be a
Yes,
different
no.
case.
No, that's a fair question, Chairperson. I think, yes, I think maybe we can frame it like this. The chair is right. It's all very well to say now, well, Mr. Kodan maybe did not come back to Parliament and what who can speculate. But I think the question from the chair is specifically from the PP's point of view. In your interactions, whether it was Section 7(9) or whatever, was that question sharply raised with a member as to A, did you correct the thing in Parliament? And if not, why not? Was there such an interaction to your, in the Audi processes?
Chairperson, the Section 7(9) notice, if we go to it, it was raising all these inconsistencies and the gaps. So it was the members' also responsibility as well to say, well, the DA person was happy, Parliament was happy, therefore I never went back to clarify the issue. But hence the issue I raised yesterday about the Section 7(9), most of the time people think, I've responded or I don't agree with this, instead of also helping, because it's just helping us with our investigation. And if that was done, possibly it was going to be a different response.
Thank you. All right. Now, the rest of it is what we went through yesterday with the Busasa report. You apply the executive ethics, you refer to Section 96(1), 96(2), 23A of the executive ethics code, and so on. And then once you have then applied those prescripts to the material that you have, then you reach a conclusion. So it's just take us through that. And I mean, I know it's not as simple as all that. In between, there's all the things we've just spoken about, Section 7(9) and toing and froing and so on. But just take us through then how you arrived at the conclusion and what the conclusion was.
So in all our investigations, you have an issue, we have issues, common cause issues, we've got issues in disputes. Then we apply the prescripts. This you've just gone through, the legal framework. And then from there, we then come to the conclusion. In applying the prescripts, did the implicated party complied with the prescripts which have been mentioned there? So, and after giving them an opportunity and audit in terms of Section 7, subsection 9, also they would bring additional information to us as I've responded to the chairperson. So we analyze all that information, and this is done by the investigator. For instance, Bianca and Rodney deliberating on the matter. When they come to me, I will say, what is the progress? How far are you? And then comment where they need clarity. And then they finalize the matter as it was finalized. So the conclusion was then the fact that having not disclosed that he had actually met a member of the Gupta family and an associate thereof in 2010. So he conceded to that. And then he argued that at the time of his response, he could not recall or he had forgotten about the meeting that in which Mr. Ajay Gupta was present at such an occasion. And it's not only the fact that Mr. Ajay Gupta was present. We should have also went further because the question was saying any other associate and or. But then in this instance, he considered that he forgot about the fact that Ajay Gupta was there. And then it was apparent that he deliberately misled Parliament in responding to the parliamentary question, in that his response is accordingly misleading to Parliament. It does not seem like a bona fide mistake, because he should have done that and clarified the matter. And again, it goes back to the issue of responding to Parliament, the issue or the intention of the executive ethics. Ethically, when you respond, don't just rush to respond. Why was he not reminded by the Chief of Staff? Because when you're supposed to respond to Parliament, normally those are sent to the minister. The minister will have to sit with the possible ministerial staff. If it has an impact with the department, the DG must also check with the staff, give me information. That with the intention of making sure that ministers, because they're executive, they account to Parliament. It means you must respect Parliament. You must make sure that you are transparent, you are honest in your response. So that's what he picked up, and that was the finding based on the facts before us, the responses and the documents we received from Parliament on this matter.
Right. Now, in relation to this, sorry, Chair. In fact, I think what I'm going to do, let's move to the next issue, but so I'll come back to this in a different format, because what I intend to do, Chairperson, to try and save time is, once we've done an issue like this and gone through it as here, is then to juxtapose that with whatever the finding was in the judgment and then move on, so that we don't have to then retraverse the issue when we do the judgment itself. Yeah. But for now, can we just move so that was the finding, and then the next issue is at 5.2, support, which is page 40, regarding whether during his tenure as SARS Commissioner, Mr. Pravin Gordhan established an intelligence unit in violation of the South African intelligence prescripts, and if so, whether such conduct constitutes maladministration. So now we're getting to the so-called rogue unit issues, having disposed of the EMEA issue in the way that you've described. And this is what we called, in shorthand, Chairperson, the establishment issue, as opposed to the procurement or recruitment issue and so on. Yeah. Okay. So tell us, firstly, what were the parameters of this issue, the establishment issue? What was said, what you found, and what you took into account? And maybe in this one, fortunately, there were common cause issues, so you used your normal format here. Not necessarily word for word or blow by blow, but just take us through the highlights.
The highlights of this this issue had common cause issues. And you see there 5.2.1, we indicate that it was not in dispute that the allegations that the unit was unlawfully established, and that it has been in the public discourse. It was something which was discussed by various institutions, legal experts, so that is acknowledged. And but the issue of my determination was whether the institution or the unit was in violation of any legal prescripts.
Yes.
So
no, I think the part that you jumped might be the most important for the purposes of what's going to follow later. That you say that it was in the public domain. I think everyone who's a South African knows that. But you also refer to the reports.
Yes.
Mm.
And then when this matter was brought to the attention of SARS, because again, you see, we are investigating SARS. And when we investigate SARS, it's because Mr. Kodan was the commissioner of SARS, the accounting officer. So we also then show that it's common cause what SARS has acknowledged in their responses, where they indicated that there was a unit and which was collecting information in respect in respect of compliance with tax and custom laws. And this was confirmed by Mr. Pillay when he responded originally to the public protector when they were investigating the human resource related complaint of 2014. And the name of that particular unit, what was it called by then? Because you'll see in the report, we are even showing you step by step how the unit changed from one name to another name to another name to another name. But we will also show that the same individuals, the same modus operandi, the same equipment, which were the subject of our investigation.
Good.
Yes.
Hence, yes, good. Hence, we just call it the unit. So
Yes.
without, because one, it was this, the CBU, the XYZ and what have you, but it, as you say, it was the same unit here. All right. Now, then at 5.2.5, one of the criticisms when you get to the judgment is that you ignored or did not take into account the Nugent Commission.
Correct.
Yeah. Well, then against that criticism, can you comment on what is contained in 5.2.5?
Yes, so this is the Commission of Inquiry into Tax Administration and Governance final report, which is the very same Nugent report. And we have captured the information that we receive a response from SARS. And SARS provided us this response where they were saying the Nugent Commission found that there was only a question why such a unit was considered to be unlawful. It's not clear. That's what the commissioner said. While a National Intelligence, a Strategic Intelligence Act prohibits the covert gathering of certain intelligence that applies to intelligence concerning threats to the safety of the state, which hardly applies to intelligence relevant to collecting tax, which indeed we agree to that members of the unit might at times have acted unlawfully. SARS employment policies might have been breached, that members might unlawfully have acquired and used equipment, all of which came later to be alleged. I see no reason why SARS was and is not entitled to establish such a unit to gather intelligence on the illicit trades, even covertly within limits. So that's within limits. It's very critical. And I must say, I agree with this. You will see later in the observations where I was very clear, because it's as if I'm now this person who doesn't want SARS to do their work, because their work is allowed for them to do that when they investigate information relating to tax evasion, illicit trade. Then he says, indeed, that was in view expressed to SARS in late 2015, which seems not to have been made public by SARS. An opinion was furnished to the former commissioner of SARS in 2015 in response to the findings of a panel chaired by Advocate Skarkane, by Trengov SC, by Advocate Ngumalo, who advised SARS that it was said to be unlawful by a panel chaired by Skarkane, but I find nothing in its report to persuade me why that was so. That's what he says. Advocate Skarkane was asked if he could elaborate, by his reply took it no further than what was said in the report. Then he goes to the Judge Kroon, the Judge Kroon Advisory Board, which reported to the minister and issued a media statement saying the unit was unlawful. But the evidence, he told the commission, that was not a conclusion reached independently by the board, but had been adopted from the Skakane. So that's what the New Gen Commission was saying, which I will show now why it this week had to capture it and indicate that, yes, it was said. And we will show why it's differently to what we were doing as the
Yes.
public protector.
Okay. Yes, that's okay. That's exactly what I want to get into. Well, we'll leave for legal argument whether the statement by Judge Nugent where he says something is not clear to him means that it's unlawful, or rather it's lawful. So, but I want to get exactly to the point you're making now about whatever the terms of reference of that commission were. We don't know for now, but we know that they're not the same as your complaint, as it were. Now, here's the thing, because this Nugent Commission, when you are criticized, is trumpeted as, shall we say, an absolution of the unit. But if you go to paragraph 9, now wearing the hat of the public protector, not of Judge Nugent, can you overlook the things that he says? He says then that members of the unit might at times have acted unlawfully, that SARS employment policy might have been breached, that members might unlawfully have acquired the use of equipment, all of which came later to be alleged. Let's just take those 3 things. If he's now acknowledging, let's say, that those things might have happened, and for him, he brushes them aside. Now, for the purposes of your investigation, if you found those things, that police employment policies were breached, members acquired equipment unlawfully, and so on, what finding would you have to come to?
You know, it's a concern because he never conducted an investigation.
Yeah.
Whereas possibly he was reading some of the affidavits and statements, which he was seeing that maybe that has been done. But from my side, I wouldn't just ignore such, especially being an investigator. A complaint is lodged. I'm there to make sure that any state functionary is compliant to the laws. Similar applies to, we'll still go to the judgment, which is criticizing me about this. The fact of the matter is, when the public protector investigate, and West being advocate, Judge Bakwa, who was the public protector, who knows our mandate clearly. When there's violation of any supply chain policies, when there's violation of the recruitment policies, and when there's violation of the law that this institution was established and it conducted its work contrary to what it was expected to do, I wouldn't definitely just brush it aside as the public protector because I'm an investigator. His terms of reference were dealing with broad issues of SARS. I was dealing specifically with the violations of these prescripts because of a complaint which has been lodged. So I wouldn't just ignore the information and brush it aside and say, because Judge Nugent has said these, and it's a commissioner, and who was not investigating. And as public protector, we were investigating because we had to check what happened, what should have happened, whether the violation of the prescripts and whether there's any gap. And how can we remedy this? Because our intention as well, going forward, is to remedy, and acknowledging that the public protector's remedial actions are binding. Going forward, the Commissioner of SARS, if these people who are surely interested in making sure that such things are not repeating themselves, they will learn from this, they will avoid doing this going forward,
Yes.
surely. Yeah.
Okay, thank you. Then that then takes us, so I think it should then be clear that you engaged with the new gender report at whatever level. Another, you didn't ignore it. Yeah. Now,
Definitely.
the next issue then is the important issue of the Trevor Manuel memorandum that you referred to earlier.
Mm.
And again, Chairperson, to save time, I won't go to the actual, we've made references to it with Ms. Mkhwebane and so on. So we'll just use it as it is quoted in the report, so that we'll
Correct.
just move along. Yeah. The references are the same as before. Right. Now, that memorandum plays a crucial role in your report. And I'd like you in particular to, okay, what we know now in this committee about it is the fact that it was written to Minister Manuel. It was written by Mr. Godin, and he was requesting certain things. But I'd like you to just read 2.1, which I think is the important part of that letter or memorandum, and then comment on what it says to you.
This 2.1 says collecting tactical intelligence invariably means penetrating and intercepting organized criminal syndicates. This is an activity for which SARS does not presently have capability, including the legislative mandate to manage clandestine activity.
All right.
So this paragraph is very clear that SARS and under Commissioner Godin, they knew that they don't have the legislative mandate to deal with this or to establish such a unit with such capabilities.
Yes. And Chair, I'd like to highlight, because Ms. Mkhwebane testified that the key activities, and we'll deal with that when we deal with the operations of the unit. But the key things, which the red flags, were interception and surveillance. That was the evidence of Ms. Mkhwebane, and where she said and it was also the using of a jamming device and so on. But those were just a few things that would, even for someone who's not familiar with the intelligence world, start giving you signals, as it were. Now, I want to zoom onto the first sentence. I see the point you make about the legislative mandate. That's fine. But it would seem that even at that early stage, there was an appreciation of the kinds of activities the unit performs. And so what do you read into that statement that says collecting tactical intelligence, which is what they were doing, invariably means penetrating and intercepting organized criminal syndicates?
This meant especially the interception of organized criminal syndicates, which they should be doing, especially if they violate tax-related matters and customs and illicit trade. But then it's very clear that the how part of it should be done by the institution which is allowed to be doing that.
Okay.
I think that's what it was meant to do.
All right. And then in case there's any doubt, the next sentence, 2.2, then says, discussions are taking place with the national intelligence to supplement SARS intelligence capability. the word supplement there, does it mean there was no intelligence activity at SARS?
This means there was intelligence, there was the SARS intelligence capability
Hmm.
because they wanted to supplement it.
All right. So let's then assume then that it will be considered by anyone that firstly, the interception activities taking place or at least envisaged, and that there was some existing intelligence capability. And in any event, if this had nothing to do with intelligence, why would this memorandum be reached with NIA, not Department of Water Affairs and so on? Why else would it have been reached with NIA?
I think they acknowledged and they understood that it's not falling within their mandate.
Hmm.
And they had to make sure that they approach the institution which is supposed to do that.
Hmm.
And I think they had at the back of their mind section 209 of the Constitution.
Right.
Mm.
Because, thank you, because we know that, well, everyone knows that the institution in South Africa that does comply with section 209 of the Constitution, in other words, which conducts intelligence services and which is governed by national legislation, is NIA and Defense Force and the police, I think. But we know those institutions, correct?
Yes, in terms of section 209 is the defense intelligence, subs intelligence and state security.
Yes, good. All right. So then another important issue, and Chairperson, I'm really raising this just for context, in the mode of what I was saying yesterday, where I said the public protector reached the same conclusions, for example, as the Chief Justice. And then, yeah, so I'm making that kind of comparison. Let's go to 5.2.8 and tell me what your comment is about this. This is now someone, sorry, I almost said comrade there. But Mr. Jabu Muleketi, who was the Deputy Minister of Finance, the letter was clearly sent to both him and Minister Manuel. And Minister Manuel did approve, as you already said, and so did Deputy Minister of Finance Muleketi. But interestingly, he inscribed, and again, Chairperson, I won't take us to that letter, there was some handwritten inscription by Deputy Minister Muleketi on the letter.
Correct.
So he approved, but as it normally happens, approves with comment. And his comment is reflected in your 5.2.6. And it says, Deputy Minister of Finance noted and stated that, quote,
0.8.
Oh, I'm sorry, it's 8, yeah, sorry, it's my eyes. 5.2.8, it says, Deputy Minister of Finance noted and state, no, sorry, let me read the whole thing. The recommendation was supported by the General Manager, Enforcement and Risk and approved by the Deputy Minister of Finance and the Minister of Finance on 22 February 2007. The Deputy Minister of Finance noted and stated that, quote, supported, however, this is a strange way of executing what I consider to be the mandate of NIA. It seems as though it's an add-on rather than part of NIA's mandate.
Correct.
Okay, now this is now the Deputy Minister, not you, not anyone else, making their own observations. Firstly, what do you read into that, and what do you think he's saying about this whole unit or the project?
This is because when you read, when he reads this submission, indeed, it's very clear that this mandate is the mandate of NIA. By then it was called NIA, which is state security now.
Mm.
And he's also saying it seems as though it's an add-on rather than part of NIA's mandate. So he's saying what we are saying, that it means there was that unit operating. Again, Chairperson and SC, I want to just stress that it will show that SARS has the capability to investigate within their mandate. Here, it's very clear that it was concerning, or it was questionable, that it's as if they are usurping the responsibility of another institution. So this is also a concern that this is a mandate of NIA, but it seems as though it's an add-on rather than part of NIA's mandate. But that add-on, it means it's something which is questionable.
All right. Chair, okay, I'll find there's a section in your report which I think you've referred to it almost twice now in giving context. So I wanted us to get
I'm
it
trying
out
to
of
do that
the
because,
way. Yeah. All right, we'll find it now. All right. So Mr. Muleketi then deals with this. Then you then go into, remember you cross-referenced that this was a matter of public interest and topical issue in South Africa and so on. Then you deal with the various reports. You refer to the KPMG report at 5.2.9 and 5.2.10, which I think is then the gist of your logic, as it were. Can you take us through that?
So point 10, the 5.2.10, this agreement meant that the two parties recognized that intelligence gathering was not within the powers and legal mandate of SARS. It also meant that there would be instances where SARS would require access to specialized surveillance. So it was just making sure that from the reading of all this and the said agreement, they were supposed to be complemented by state security. So it was not the responsibility of SARS to deal with that particular surveillance, or they didn't have that specialized capability, which doesn't fall within their mandate. And 11, it means we then go further that this MOU did not materialize as intended by SARS, and then resulting in SARS continuing to develop its own capabilities. And I think 12 still goes further to show that SARS approached Minister Ronica Strills, and where they were still wanting to requesting an approval for the establishment of this deep COVID capability, which will give both NIA and SARS to work to collaborate.
Yes. Okay. Now,
so this was not approved by the then Minister of Intelligence.
Yes. Okay. Now, yes, I found the place where I think that you were burning to explain as part of the context, which we jumped. And I think this is important, Chair. If we can just go back to 42, I'm sorry. to page 10 of the report.
The executive summary.
Yeah, page 10.
Okay.
And I think this might well be the most important observation, just to put into perspective for the committee, but also for South Africans and for anyone who might say that you did not want SARS to be chasing tax dodgers and all sorts of people who might have been legitimately targeted by the unit.
Correct.
So if you can just read out the
So it's observations and again learning from the state of capture judgment of the Pretoria High Court, where they said observations can also be regarded
basis,
as, yes.
a basis for remedial action.
Yes. So my investigation of the establishment and activities of the intelligence unit by SARS should not be viewed as stifling the effectiveness and efficiency of SARS in their investigations into tax evasions and the curbing of illicit economy, but is to ensure that they do not encroach in the territory of the State Security Agency. Perhaps consideration should be made by the two institutions to conclude a memorandum of understanding so as to have collaborations as and when the need arises. So this was putting it out there, and as well to make sure that I'm not against and I support the issue of them having to conduct illicit activities. And as the chairperson, we will go to in the report where also it is very clear in terms of the South African Revenue Tax Act, that investigation unit, what powers it has. So you'll see when we deal with it under legislative framework. And it's very clear what they are supposed to be doing and how they should be conducting their investigations.
Yes.
Yes.
So yeah, so then it would seem that your job was much a simpler one than all these dramatic things that are suggested. You were not passing moral judgment as to whether SARS can collect intelligence or in whatever way they wanted, but simply looking as to whether in so doing there were any breaches of our laws, constitution, regulations, and all that.
That's
Procurement
all what we do.
policies and so on, but not necessarily to stop the unit itself.
That's what our intention is, and to support them as SARS, do things within the law and the prescripts of the law, do not perpetuate unlawfulness, be compliant to the law as it stands. So that's all what we are doing, and that's all what we were intending to do with this report.
Yes. And if you extend that to a simple issue like the recruitment of personnel, again, you didn't say, no, you must employ this one, don't employ this one. I don't like this one, I don't. It was a simple question of whether those people that they want to employ were employed in terms of the applicable HR policies and so on.
That is definitely correct, because if you check our investigation, simple issue, what is your policy saying? Yes, possibly because we dealt with the issue of these people, it seems as if they were seconded. But what is your policy saying about that? Comply to your policy. If you want to second them, do that. If you want to advertise and get skills from outside, what is your policy saying? Follow the normal recruitment, your recruitment policy. And if you, for instance, possibly their policy doesn't provide for secondment, that will be a thing where we say, amend your policy so that you have a secondment and then you are compliant. That's all what we were intending to do with this process.
All right. And at the risk of stretching the point, if you apply that same logic to the equipment, the procurement of equipment, what were you looking for there?
There,
Again, whether it's a jammer or whatever device, would that have been your concern insofar as procurement is concerned, or what were you looking for under that heading?
I know we want to move to that, yes, but there's a point I
No.
want us to come back to.
Sure, please.
Yes, maybe let me start with that because it still deals with the recruitment, recruitment. Page 44, it deals with the unit was staffed by what kind of skills of those individuals.
Sorry, you're reading at 5.2.15.2.
Yes. The unit was staffed by former intelligence,
Sorry,
law
just a
enforcement.
minute, okay.
Okay.
5.2.15.2.
Page 44. So this deals with the legal opinion of Advocate Vem Trengov, SC, and Advocate Norman, who gave a legal opinion. You know, okay.
Yeah, there you are.
Yes, because they were requested to give an opinion on the Sikakane
15.2.
report.
Sorry. Yeah.
On the Sikakane report. So the legal opinion then picked up that the staff, because we're dealing with the issue, I want us to just conclude the issue of the recruitment. It was very clear that the people who were recruited or who were staffed in that unit were former intelligence, law enforcement, and tax professionals. And it conducted investigations using methods, techniques, and equipment normally used by the intelligence and law enforcement agencies.
Okay.
So those are the red flags. Now come to the SARS investigative powers, which I mentioned earlier. Oguti, what is the Tax Administration Act says about investigation? What SARS, because this is also at the core, SARS powers to conduct various types of investigations for the purpose of the administration and enforcement of tax legislation. So these investigations range from the least invasive to the most intrusive. So this included the request for information from a taxpayer, arriving at the taxpayer's premises without prior notice, requests for a taxpayer to submit for interviews, conduct audits and investigations on the premises for any person by prior notice.
Yeah.
So their investigation powers as well are only limited to what the tax legislation is saying. So they may not do any other investigation that intrudes upon the privacy of others without the statutory powers to do so.
Okay.
So this is what they were expected to do. So I'm just showing you that when we take it further, this is the opinion, and the opinion is also acknowledging that the people who were working there, what kind of people were they? But as public protector, we didn't just take that and say it's gospel truth.
Yes.
As public protector, then you'll see on the recruitment, because we wanted the names, we wanted to know, was it advertised? If it's not advertised, you seconded them. Where is proof that they were seconded using the proper process? Because when you second somebody, there must be a submission, like that submission which was requesting funding, because those are the internal documents of SARS.
Okay, thank you. And I think, thank you for highlighting that. But I want to really situate that response to, again, to simplify it really, as a public protector, I'm a member of the public. And the issue is, so where do you come in all this? Why are you involved in this as a public protector? And I think that issue about the privacy of citizens, then which was highlighted by the two advocates, come through, and the Section 209 connection, because Section 209, remember, this is the Constitution, it's not legislation. So
Correct.
what it's really saying to me as Mr. Citizen is that as I walk around, I must be sure that all sorts of institutions don't have the right to establish private armies or private intelligence officers. That the chairperson can't just wake up tomorrow and say, okay, I'm now going to have an intelligence division of this committee without which can spy on me or my attorneys or whatever. Isn't that the essence of all this? Is that, and I want you to unpack that. What is the interest of the public protector in all this? Because the SARS could say, well, why do you care? If we want to have an intelligence unit, it's got nothing to do with you. It's we are collecting tax and leave us alone. Where is the public protection angle in all this?
Remember the public protector's mandate in terms of the Constitution. Again, investigate improper conduct in state affairs, but that is done with the intention to protect the public. Public Protector Act is saying we investigate abuse of power, and any institution which is performing public function, they should perform the public function and be compliant to what the Constitution and the various legislative prescripts are saying. So in simple, straightforward work of the public protector, SARS, do your work, be compliant to your own laws. Do not encroach on other institutions' legislative mandate, but as well, even if when you do your investigations and you are within your right to do that, also still comply to your law. So basically the public protector, that's all what we do, because we don't want a situation where things are then, normally I would say, we investigate maladministration. We should be dealing with that at a very early age, because if we pick up such things and we don't learn from them, then it means it will perpetuate into a situation where the citizens' rights will be violated, not even the public's rights will be violated. Your rights to privacy, even if it's not relating to tax, but then you find that the unit will then investigate you or access your information or even follow you. So we're still coming to the operations of the unit and the information which was before us when we investigate. So is to protect that, because we want a state where you respect the Constitution irrespective of who you are.
Yes.
It was purely to protect the public and nothing more, nothing less.
Yeah. And when we deal with the judgment, we'll deal with all those issues. Yes. Whether really, in your view, then if you are judging this kind of thing, even as a member of the judiciary, should you be nitpicking on technicalities and all that, or the whole issue of the protection of the public and the dangers that might arise? Should a unit like this be left to roam around the country?
You know, the justice system or the judiciary or the justice system, I know we said they are focusing on the papers before them, but I think in whatever they do, they should also having that broader perspective to say the judgment which we are issuing, what impact will they have to society at large? Because the issue of justice needs to be seen to be done. There's a number of issues we'll speak about on those issues, but as a judge adjudicating this kind of a matter, you should then be worried that if this is left unattended, we just focus on Section 9, we just focus on just saying the public protector was biased. But what was the public
Or
protector
whether it
trying
was 2 years later.
there's Section 6(9), the issue of that. But what are we saying about this unit, which is not compliant, and public protector is trying to remedy that SARS, put your house in order, and any other institution which is not mentioned in Section 209. And the president doesn't know about this and hasn't given authority for that institution to proceed, like Parliament speaker the next moment saying, now I'm establishing this unit. Then it means anyone can do that. What are you doing to the issue of invasion of the rights and privacy of people? So I don't think that's the country would want to have.
Okay.
Okay, thanks.
Maybe just to indicate before we take a 10-minute break,
Mm.
I think the advocate and both of you earlier on the day, you've nicely listed the headings.
Yes.
On this is about 5 or 6 of those.
Yes.
I think we've done with EMEA. We're
Yes.
now on to the establishment. So it will be important when you come back for us to hear what is the summary of evidence on that
On that,
establishment.
yeah, fair enough.
And then we
Thank
go,
you, Chair.
go to the rest.
Thank
But
you.
can you take a 10 minutes tea break? Thank you.
Recording.
Thank you. Welcome back. Thanks.
Okay.
From the tea break, we'll get into our last session. Advocate Mbofu, back to you.
Thank you, Chair. All right. Okay, I think I'll continue to use the report as our source document until it's not possible to do so. But because what I wanted to do in rounding up this second issue was to refer to Mr. Kotan's section 7.9 response, where you'll remember that I put it to Ms. Mkhwebane that his response really almost amounted to what I called loosely a confession that yes, indeed, he was involved in the establishment, and then he makes certain remarks, but we'll get to that when we deal with the section 7.9. So far, we were at the point where we were cross-referencing the remarks of Mr. Muleketi, and then UPP then took us to another cross-referencing, which was to the Trengov SC opinion.
Yes.
And then we then spoke about what we call the public implications of this and section 209. Now, we will, okay, maybe let's do this. At 5.2.1.15.6, still in the Trengov SC opinion.
Yes.
And again, I'll just be selective because I think we did a similar exercise with Ms. Mkhwebane. Just to give a perspective to someone sitting at home and listening to this, the type of activities used by the unit at that time, what they included according to the Trengov SC opinion. On that list, can you look at and we'll juxtapose that against what you were saying about the interests of citizens?
Okay.
Item A.
Chairperson, I just want to still insist that this opinion of Trengov and Mkhwebane was also saying, which we agreed to, that SARS may not do anything which is outside of the tax law. So item A was the surveillance of individuals, which the special projects unit and analyzed by the legal opinion team included the surveillance of individuals. So that is what the opinion was saying.
Yes.
This unit was doing.
Okay. Right. And as I said, those are some of the key what's called red flags that Ms. Mkhwebane identified. Surveillance, interception, and so on. And let's go to item G as to what the unit was also doing.
Listen into and or electronically record third-party conversations by using listening devices.
Yes. Item J.
Accept information from a person while knowing.
Sorry, it's my eyes. Item I.
Okay. Obtain information from informers on the understanding that the identity of the informer will not be revealed.
Item J,
Accept information from a person while knowing that information was acquired unlawfully or illegally by the person.
right. Now, the question I really want to ask is, again, it's just a random selection. Well, it's not random, a cross section of some of the activities of the unit. But I'm just saying, what message, if you're trying to check whether this indeed exhibits signs of being of the intelligence world, what impression would you get if a unit was involved in such activities as just the 4 that we picked out?
Well, on the face of it, it's concerning because you cannot just accept information from a person whilst knowing that that information was acquired unlawfully and illegally. I mean, we have laws in the country which needs to be respected. And even K, I mean, it's used other abusive practices or threats. So it means to secure a particular outcome by consent. And their investigative powers should be within the limits of the tax administration law. But then those are the things which were picked up. And even the fact that the interception of and listening of people's information, that also should be done within the law, because we dealt with that legislation which needs the approval of the judge to do that. So that's the information which, even besides the Skakane report, but the legal opinion on conducting and checking all the available information, that's what they've picked up.
Yes. All right. And then the 5.2.15.8,
Yes.
I think that's the one that deals with the permission by the judge. What was then the conclusion of the Trengove
Legal opinion.
opinion?
He says, however, from the evidence reviewed by the panel, such officials were prohibited in terms of the regulation and of interception of communications and provision of communication related information act from interception communication of individuals under tax investigation. So they were prohibited to do that.
Okay.
Because possibly it was clear that there was no evidence that they acquired the relevant approval
From a judge.
from a judge.
All right.
Correct.
Then the next section deals with the Skakane report. I'm not going to deal with that now because I want to deal with all those reports tomorrow in one section, so that we don't hop around among them. But what's your investigators, your team, had access, just to confirm, they had access to the Skakane report, correct?
That's correct.
Because the Skakane report, as we know, was produced in 2014, I think. Your work was being done in 2018.
Correct.
Okay. Now, so they refer, one of the reasons I don't want to go through that, they refer to some of the material we've already spoken about, the Trevor Manual memorandum and whatever you.
Yes.
But then at 5.2.23, that's on page 48.
Yes.
This is where there seems to be then a coincidence of conclusions between you and Skakane, at least. And I'd like you to read out, that's their kind of conclusion on the establishment issue.
Yes, where it will seem that at this stage, SARS recognized that it had no statutory authority to collect intelligence.
Hmm.
And then the report found that there was prima facie evidence that the SPU engaged in functions that properly belong to other government agencies and that SARS had no authority to perform.
Hmm.
And there was a real possibility that the SPU undermined the work of government agencies tasked with investigation of organized crime and the collection of intelligence.
Yes. Yeah.
So that's what
Their
this-
conclusion. Yeah.
Yes.
All right. Now, 5.2.25 is important because it provides the platform or transition from, as it were, Sikakane to the well-known IGI report. Can
Correct.
we read that out?
The report recommended that the activities and functions of the SPU be investigated by the Inspector General of Intelligence. So can I elaborate on this?
Yes. In other
Um,
words, the Sikakane report.
yes, this Sikakane report.
Mm.
Because of the picking up of information where they have moved out of their mandate, they encroached into the mandate of SSA. So I think also that creates a lot of confusion because people say, but this unit was not an intelligence unit, but their activities were in such a way that it fell directly within the mandate of SSA. And I mean, taking the approval, the approaching of Minister Trevor Manuel and all those. So hence, in a meeting we held with the Inspector General of Intelligence, Dr. Dintwe, on the 31st of January 2019, he confirmed that the Office of the Inspector General of Intelligence had indeed previously investigated allegations of an intelligence unit within SARS and confirmed the existence thereof.
Yes. All right. Okay, Chair, I'm just flagging that issue. We will come back to it. You'll remember that right at the beginning, I can't remember how many days into this committee, there was a transcript, or rather an audio material that was played by the evidence leaders, which related to that particular meeting.
Correct.
Yes. And that meeting, there seems, again, it goes to this whole issue as to whether anybody really was under any impression that there was no report in your possession. But we'll go through that recording. What we will do, Chair, is to provide a transcript. In fact, I don't know, I think that transcript is already part of the record.
It was done that. If you could, sorry, Chair. There is a transcript of the record.
Yeah, it's 1/4 page. It's bundle K, item 13. Maybe let's just display it because I just don't want to get into it now. But bundle K, item 13, page 1466. Yeah. All right. Just show the attendees.
Yes.
Right. Okay. So this is a meeting that is referred to in that paragraph you just read. And who was present there?
It was myself. It was Mr. Nyembe, the late Mr. Nyembe. It was Ms. Mkhaladi, the executive manager. It was Mr. Rodney Mataboche, the chief investigator. It was Advocate Jay Kavenda from the legal advisor from IGI, and Mr. Ephraim Kabinde, my PA.
Right. Okay, and this is the same Mr. Kavenda who has recently submitted an affidavit to this committee, correct?
That's the same Ms. Kavenda, yes.
Miss Governor.
It's a miss.
Let's say Advocate Governor. Yeah.
Yes,
All
it's
right.
it's a miss.
Her affidavit is you have read, and I indicated to the evidence leaders that you would want her to be called at the appropriate time, but for now we're working on on her affidavit as it is. I just want to we'll come back to this transcript, because I just want to deal with your statement there that in that meeting, effectively, they confirmed the existence of the report. And I think they said the custodian was the minister and so on. But
That's correct.
yes, we'll deal with that when we do all the reports themselves.
Okay.
Anyway, then you deal with the interviews with the Minister of Security. What was that all about?
And that was still my effort to assist the team to determine the veracity of the allegations of the existence and the activities of the intelligence unit. I sought more information from the Inspector General of Intelligence, and information, this information was attributed to a report by the former intelligence. So I subpoenaed the minister. I had a meeting with the minister, still with the intention to say, and I informed the minister that I have this report, and this report, I want to make sure that I get it legally from the institution which produced it. In fact, the custodian of the report, because IGI informed me that the minister now is the custodian of this report.
Right. Now, again, and this now talks again to the allegation that you were concealing that you have this report. If you got 529, 530, and I think 532, you use the word that the minister undertook to request the Director General to avail the declassified copy of the report. The emphasis is on declassified. And then you said, I have yet to report to receive the report as promised. And then at 5:30, you say again, I will be requesting the new minister and at law to avail the declassified report to my office. Then 5.3.32 again, I've since requested the President Ramaphosa's assistance in facilitating the availing of the declassified report by the Minister of State Security to no avail. Now I want to, in all those, when you are saying you wanted the declassified copy of the report, what was the emphasis between that and whatever you had?
It was because acknowledging that the report is a classified document and how to treat a classified document, and also understanding as well from the meeting I had with the IGI and in January, where the key issue was how do we make sure that their sources or the agents are protected? Because remember, this report was not only dealing with this SARS unit, was dealing with other information and other individuals who are supposed not to be exposed. And as well, the very same issue of how the agency is operating. Now, my insistence of the declassified report was acknowledging that I would want to use that document. And remember, in the sources of document which I've indicated, I said there's some documents and equipments which were blinded and documents which I cannot disclose. So it was all in the intention of making sure that as the pipe protector, I also operate within the provisions of the law and I act responsibly in protecting those sources and covert agents and operators and how they are operating. So all this were my efforts to get the document which is declassified from state security to no avail.
Okay. Then you then say at 5.2.33, in light of the above mentioned and the terms of powers vested in me by section 181, 2 and 3 of the Constitution, I have it on good authority that the findings of the OIGI report inter alia were that, and then you say what the findings are. Firstly, SARS created a covert unit using intrusive methods and so on, in violation of section 209. And then you say the establishment was illegal. And then the IGI recommended that criminal charges be investigated against Mrs. Godan, Pillay, Van Lochenberg, and Richa for the establishment and involvement in the covert intelligence unit in SARS, and SARS to produce a credible inventory of the equipment and so on. Okay, now again, that's exposition, as it were, of the recommendations on the IGI report. I mean, it says explicitly, the IGI report recommends that. Yeah. Could you say that if your intention was to conceal the fact that you had seen it?
It was not, I mean, it was not my intention. In fact, I don't understand where does this come from that I said I haven't seen the report when the judges and everyone had at the beginning where I said the report was dropped at PPSA by somebody. Secondly, the issue of me writing those letters, which we've mentioned up there, and the letters are so detailed because we availed them through Rule 53 and even everyone, and even in the Section 7.9, that here is the issue, there is this report, I have it, and can I get the correct document? Because Section 181.3 of the Constitution demands that state institutions, organs of state, anyone must assist the public protector. I was requesting to get that from the custodian of the report. And I have it on good authority that the findings are as follows. It was because when I allowed that these recommendations and what these findings and recommendations to be in this report, it was because it was relevant for the complaint and the violation of Section 201.
Yes.
So if you can see here, I showed what the findings of that was all about, because there is this unit which IGI was requested to investigate whether its operations is legal, which is the mandate of the public protector. And that's where I then said, okay, going through this report, I could find that what is relevant for me, instead of being irresponsible and say it should be only focusing on or putting all the information here and exposing those intelligence information or sources. So here I was trying to make sure that I act responsibly. And this is exactly what is in that report and the recommendations. So this shows that I've seen the report and the good authority. In my opening statement with the IGI Inspector General, will listen to that, or even to the record transcript. I told him the report was dropped. Strangely, I've even seen it in Newsweek. And the same document. Was there such an investigation? yes, there was my predecessor, the late Faith Radebe. This is what is happening. So yes, but we'll
Yes.
still go through that
No, yes.
recording.
I think maybe, yes, we will. And that's what I was avoiding to do now, to do the blow by blow right now. We can do it in another session, but in a nutshell, I'll just ask you a few questions. In your interactions with, whether it was the minister, the IGI, advocate governor, and all that, did anybody ever say, no, there's no such report? We don't know what you're talking about.
Definitely not.
And did they go as far as to even confirm the date on which the report was finalized?
Correct. And even in those letters, when
Yes.
they were responding.
And those dates on that information, did it coincide with the report that you had?
Correct.
So, short of giving you the report, these high-ranking, the inspector for intelligence in South Africa, the minister, the legal advisors, and so on. The question I really want to know is if any one of them ever gave you the impression that the report that you had, or even the one that Nosewick had for that matter, was not the report.
Not at all.
And would you regard the minister and the IGI and advocate governor, collectively speaking, as good authorities on that issue?
Correct.
All right. Now, okay, then we deal with the KPMG report, and Mr. Moyane appointed KPMG report in 2014. Okay, so this is
Correct.
now a second report, which we will deal with when we do the reports. But I think Mr. Pilay's evidence was that he is the one who commissioned the Skakane report.
That's correct.
And his successor, Mr. Moyane, then, according to this, commissioned the next report, which was the KPMG report.
That's correct.
And in a nutshell, we won't go into it as well now. What did the KPMG report find regarding the lawfulness of the establishment of the unit?
The covert unit, intelligence unit existed, which is 5.2, 35.1, page 50, and varied in its form and shape. Evidence indicated that the NRG only started existing in 2007, even though reference is made to a covert unit being operational as far back as 1998.
Okay, can you jump to 5.2.35.7 and 8?
Maybe 2 is very critical because that's what now this unit, sorry, Chairperson.
Yes.
You see, it was labeled various names, Special Operations, SPU, NRG, HRIU, and there's a part where we also then deal with, I think it's 7 or 8 names which were used to label this unit. So the members of the unit were not employed by SARS as they were recruited outside of the SARS acknowledged systems and processes. So the members were not the SARS employees, but they were recruited from outside of SARS.
5.2.35.7, if you can read that out.
So there was clear evidence that the intelligence unit intercepted private individual communication, which was corroborated by Mr. Van Logenbeck's laptop, which was found with unexplained emails appearing on his allocated laptop. So that's what the KPMG finding was. So we just captured as is per their findings.
Right. Okay. So this is the second one. Again, we've glossed over the 3 reports now. The Skakane finds that it was unlawfully established. IGI says that there should actually be criminal charges against Mr. Gordhan, Pillay, and Van Lochenberg and Richa. And KPMG says that there's clear evidence of interception of private individuals. Okay.
Okay.
Yeah. Then, and then they also talk about the recruitment. You've read 5.2.35.8. I think you've read that.
Yes, I've read that.
Yeah.
Yes.
Okay. So, which they say was outside the system processes. Yeah. Okay. Then again, another accusation is therefore is that you ignored, quote unquote, the responses of Mr. Gordhan and Mr. Pillay and Mr. Mkhwebane, basically, and just forged ahead with your predetermined outcome without taking into account their responses. Now, taking into account the sections that follow, what do you have to say about that?
The affidavit of Mr. Gordhan, he was approached, and I think we're still going to deal with the challenges one faced with this investigation, the recording of meetings with Mr. Gordhan, the subpoena and everything, but he responded because we've captured and incorporated his response in the report. So here we were requesting him to clarify the establishment of this unit, and he acknowledged that this unit had different names. He says the unit didn't have a name originally, 5.2.36.1, as the Special Projects Unit at first, later National Research Group, and the High Risk Investigation Unit respectively. The manager of the unit reported to Mr. Pillay in his capacity as General Manager, Enforcement and Risk. Mr. Pillay in turn reported to Mr. Gordhan as the Commissioner of SARS, the Accounting Officer. So it's going back to why the Section 79 was served to the two of them, including Mr. Mkhwebane. So because of their role and their level in the system. So, and he said the unit was lawfully established to perform very important functions for and on behalf of SARS. As far as he's aware, the unit operated and performed its functions within the law.
All right.
And then Mr. Pillay as well was given an opportunity. This is part of ODI. This is what we told him about the investigation, about the report. And he said he denied the allegations. He then says, he argued that the Skakane report was full, vitally flawed in fact and law, which is 5.2.38. And then he said he denied that the establishment of the intelligence unit by SARS failed to respect the constitutional status, power and functions of the National Intelligence Act. Then he maintained that the relationship between SARS and NIA was generally sound and managed in accordance with the Constitution, mutual interest and joint subject matters. And then he listed the relationship which existed between SARS and NIA. And I mean, we are capturing all that and we are showing that we did indeed take into consideration the relation, the response of Mr. Gordhan, Mr. Pillay, and then the affidavit of Mr. George Mkhwebane. We also had a meeting with him. We asked him, we said he must also tell us about this unit. And
Sorry, I'm sorry, PP. Just going to the previous one, Mr. Pillay's responses. Where he refers to, he says there were various joint investigations between SARS and NIA. There were various joint training and all sorts of things. Does that suggest that the unit had nothing to do with intelligence or or what does it suggest?
I think here he was just trying to show that NIA and SARS or state security has a relationship with the state security agency. And I mean, if you have joint investigations between the two, which is good, because this is actually what is expected from them instead of usurping the powers of state security. And it means the officials who are doing all this work needed to be trained in this kind of work.
Yes.
Various investigations and audits conducted by SARS at the request of NIA, I mean, which is also in the spirit of cooperative governance, section 41 of the Constitution. Various investigations conducted by NIA at the request of SARS, various training courses presented between the two, a memorandum of understanding between SARS and NIA dated 2002. So this is what they were supposed to be doing. Remember, we are acknowledging you doing good, but the fact of the matter is, then there is this unit which usurped the powers. I think that's what they didn't understand. I don't know whether it's as simple as that. We're saying it's fine, respect that NIA or state security is the only agency per section 209. So indeed, if you've got training, you've got collaborations, it means that you were trained, but then I think the training also should only focus on when you do your own, within your own mandate, this is what you need to do. And joint operations are good and joint investigations are good because that's what they were supposed to do instead of taking the responsibility.
Okay. Okay, I've been asked to check. I had someone to remind to
Yes,
check.
please,
How are
Chairperson.
you? How are you feeling?
Wait, we have a drill from yesterday, so she will indicate. We have agreed to that, so I'm wide awake when
Okay.
you need that.
Maybe I-
Wamkulu.
I've got my own.
Yeah,
My
no,
own
that's offline.
people.
Yeah, that's offline
All right.
arrangement.
another 10 minutes, Chair. Then I can stand for 5 minutes and then, yeah.
Thank you.
Okay.
Let's
Can go
proceed.
on for another 10 minutes.
Yes.
Okay, thank you. All right. Thank you. Thank you, Chair. All right. Now, all right. Can we, again, just to save time, I think the same general answer applies to Mr. Mahashul. He also responded, you dealt with his response. I don't think we need to go through it.
Yes, because he
in
was
detail.
also the accounting officer.
Yeah.
And by then he was in HR, corporate services. So we wanted to know,
Okay.
do you know about this? Especially the issue of recruitment, the
yeah.
establishment, he was key
Mm.
in this particular process. So we also incorporated his response. We'd never ignored his response.
Yes.
We incorporated.
Okay.
But here, Chairperson, I think the key issue is the issue of Audi, the issue of giving them a hearing and incorporating their information.
Right. Thank you. Now, then comes what I think is the core of your first step process from 5.2.44, where you deal with the application of the relevant legal prescripts. And again, we
Definitely.
won't go deep into them for now. They're there. Members can read for themselves. But high level, it was the Constitution, which we've already dealt with. And there you specifically refer to 41, which is the cooperative governance section. 209, the one that we read earlier. 195, which is the ethical standards of organs of state. And the section 199, which talks about the integrated defense systems and intelligence and police services and so on. And then you go to legislation. And the legislation which was relevant, in your view at least, was National Strategic Intelligence Act, That's 5.2.48. And then you outline what that act provides. The Tax Administration Act 28 of 2011. Yes, PP, you wanted to come in there?
5.2.40, yes.
On 40.
Okay, yes, yeah. Because I wanted to just indicate that on the
Mhm.
issue of, again, for members, they will read for themselves, but it's very clear why.
So,
Where are you?
so
In the legal framework,
but yes,
legal framework, yes.
legal framework, yeah.
It's from 44, Tsepo, sorry.
But for, yes, I had just summarized the constitutional provisions.
Yes.
Yeah.
And then we went to the,
Legislation.
okay,
Which starts at 5.2.48.
oh, yes.
And I mentioned the NSI Act, which you dealt with, and you quoted. We don't need to go deep into it now. And then the Tax Administration Act.
This is very critical as
the
well.
Tax
because-
Administration Act. Okay.
Yes, it's very critical.
All right. Want to highlight something there?
Yes, as section 41,
Mhm.
it says senior SARS official may grant a SARS official written authorization to conduct a field audit or criminal investigation.
Hmm.
Then when they exercise their responsibilities under the Tax Act in person, the official must produce authorization. If the official does not produce authorization, a member of the public is entitled to assume that the official is not a SARS official as authorized. So this indicates that when they conduct their investigation, this is what they need to do. So, and then in terms of section 44 of that act, page 57, during a criminal investigation, SARS must apply the information gathering powers in terms of the chapter which due recognition of the taxpayers' constitutional rights as a suspect in a criminal investigation. So again, whatever they are doing, they should comply to the law. This shows that that's what they need to do. In terms of section 46, again, whether identified by name, require the taxpayer or another person to, within a reasonable period, submit relevant material. So that is what SARS is expected to do. So paragraph 5.2.55 is very critical. We're saying, however, when one considers the evidence at my disposal, which points towards specific steps taken by SARS to recruit personnel and procure surveillance equipment for the said unit for covert tapping of people's telephones and conducting illegal surveillance on people, it confirms that SARS violation of the legal prescripts which dictate when such covert activities may be permissible. So they can do those, but then they should be doing those within the legal prescripts. Now, coming to the conclusion, that's where we are applying the law to the facts. So we are saying SARS is not mentioned in terms of the relevant legislation as the one, as one of the national intelligence structures established in terms of the NSI Act. And it can only work with other law enforcement agencies within the principles of cooperative governance. So you see, Chairperson, where I was mentioning that Mr. Pillay mentioned that they cooperated. So that's where they can cooperate with other law enforcement agencies.
All right.
Yes.
Okay. Well, firstly, quite apart from the content of what you've testified about now, what does all this say about the criticism that you ignored the inputs of the implicated persons?
I mean, that's why I'm saying it's so unfortunate, and a reasonable judge and a reasonable person who's reading this report would see that we have incorporated the evidence or the information we received from Mr. Pillay, Mr. Godan, Mr. Mahashula, so that we can, because there were questions we asked them, we requested information. At first here, we asked them to provide us with their affidavits in the document collection process. Remember, when we receive a complaint, we will then, after meeting the complainant, logging issues, then we will write to the individual and say, give us an affidavit. These are the allegations against you. So this is what was done in this particular process. And they responded. So this is the first audit. Then we will still come to the second audit of giving them the section 7(9) notice to say, this is the information you provided. This is the evidence we're having. You are implicated in this matter. We're giving you an opportunity then to give us the second bite now to these issues.
Yeah.
Yeah.
Okay.
So
yeah.
it's here in the report.
Yeah, I know. Well, I know the chairperson said I must not dish out compliments liberally. Yeah. But speaking for myself and having read all these things so many times, I say that this is one of the best reports I've ever read from the public protector. But be that as it may,
Yes.
I'm not a member of parliament. But and you saying you had said that regarding that remark, whether it's correct or not, that Mr. Matabuche, who was the chief investigator, was one of your best craftspeople. Would you say the quality of this report was related to that fact?
Mr. Matabucha, yes, he prepared the Busasa report. This one was prepared by Bianca under the guidance of Mr. Matabucha, which
Yes.
is also well drafted. She's also one of the best
Yes.
drafters. And I
Well, I
used
know
to comment.
she's one of the best witnesses, but I didn't know she's also one of the best drafters.
No, she's the
Okay.
best. And I mean, at this level, she was at level as an investigator, not even a senior investigator. So, and it was one person who will also do with her experience, but also at her level, a number of investigators, they would do your service delivery related matters, but she was one of those who were falling under good governance and integrity, who were investigating complex matters.
Yeah.
So I think she was also one of the best. A number of them are the best investigators, I must indicate.
Yes.
I'm sure that time will come when you need to give awards. We're not there yet.
It's not. I'm telling you, the chair, thank you,
Please
Chairperson, yeah.
proceed, advocate.
You'll tell us when it's time for the Oscars. Yeah. And the drafter of the year. And well, I think when you go back for when you go back
5 minutes stretch walk.
yeah, I was going to say when you go back to
The 5
office,
minutes.
then you must do the awards.
Recording stopped.
Thank you, Chairperson.
welcome back.
Recording in progress.
UPP, over to you, Alvin both.
Thank you.
Thank you, Chair. No, PP, I was saying, I hope you took the hint from the chair that when you go back, you must organize the Public Protector Awards,
Definitely.
and we know who the keynote speaker will be.
None other than the chairperson.
Thank you. All right, now just to round off that second issue then of the establishment of the unit, having dealt with the prescripts, the history, the other reports, the affidavits of Mr. Pillay, Mr. Kodan, Mr. Mkhwebane, and all that. You then come to your conclusions, which we find at from 5.2.56, and I would just like you to then just maybe without even reference directly or reading directly from your conclusions, to just tell us why you say that then that allocation was sustained, as it were.
Yes, again, our conclusion, taking into consideration the complaint, the responses we've received from SARS, Mr. Kodan, Mr. Pillay, Mr. Mkhwebane, then we then came to the conclusion that the national intelligence structure, which is established in terms of NSI Act, and can only work with the law enforcement agencies. So it means that unit, good, it was there. And indeed, they should investigate. We want them to deal with the tax evaders, unlawful illicit economic trade, which is affecting our country. But it should then operate within the law. And then we also say in 5.2.57, page 58, that SARS, under the guidance of Mr. Pillay, as general manager.
Did you get that? I don't see it.
Yes.
Just repeat that, PP.
5.2.57 of the report, page 58.
Thank you.
Yes, they established this unit, which was without the involvement of NIA then. And 58 also, it shows that in the memorandum which Minister Kodan, as the commissioner, when he was writing to the minister, he said SARS had already begun operating a unit that gathered information covertly. However, as the accounting officer, Mr. Kodan should have been aware, and I believe was aware, that the unit had already started operating. Mr. Pillay reported directly to Mr. Kodan as commissioner of SARS, because how that memorandum was crafted, it was showing that this unit had already started operating. So as the accounting officer, he should have been aware of that. So the establishment of the unit with the approval of Mr. Kodan as the then accounting officer was in breach of section 209 of the Constitution, in terms of which only the president may establish such a covert information gathering unit. I think we've read section 209 earlier.
Yes.
So then Mr. Mkhwebane misrepresented himself under oath because he denied the existence of the intelligence unit. Even if the unit was never called a rogue unit at SARS, the operations and functions of CBCU, a unit that he was fully aware of existed, were similar. Hence, I said this unit was changing names over and over and over. And he just said he denied the knowledge of any unit which is doing this kind of work. I mean, being the general manager responsible for recruitment or corporate services. Surely he should have been aware. Everything should be approved through him. That's what we call, as an organization, complying to the law, your policies. And I think if they are audited, the Auditor General, if they audit something like this, they will also come up with these findings and then advise them accordingly. So further, due to the sustained denial of the unit's existence, as well as the failure by Minister of State Security to provide my office with a copy of the declassified report on the investigation conducted by the then Inspector General of Intelligence, Advocate Faith Khatebe, on the affairs of the unit, I have requested the President's intervention in the matter. So also up there, we've mentioned the letter to the President, because in my effort trying to make sure that as public protector, I'm assisted, I have this evidence, and I use this evidence accordingly.
Your mic.
Yes, thank you, Chair. No, fine. I think let's rather finish this. I just wanted to interpose something else which might have relevance to CX and other issues, but let me rather do it once because we're at the end of this section, or the second pillar of the six pillars of Part A. All right, maybe let's round that off. So those were your conclusions in a nutshell, PP, and on the basis of that, therefore, you came to the conclusion that the allegation was sustained.
Yes, it was sustained, because if you check 5.2.62 as well.
6.2, yes.
The evidence obtained during the investigation indicates that State Security report found, amongst other things, because we are mentioning that report again, amongst other things, that SARS created a covert unit utilizing covert and intrusive methods in contravention of the SARS mandate.
Yes.
So this is also showing that I wouldn't say something like this if I don't have the copy of the report.
Yes.
And SARS had an interception and monitoring of communications capability, which went beyond targeting tax offenders, but also utilized for political purposes, as per the documentary evidence in my possession. So this also, it's not just the thumbs up. Political purposes, I have indicated that there were documents and videos which showed, besides the interviews or the recordings of the meeting of Mr. Those recording of Helhart, which we're going to pay Deval and the
Lombard.
Yes. So where they were confirming that indeed this is what they did, they installed those cameras at DSO. Yeah. Yes, the intention was something different, but unfortunately it ended up having to go beyond the mandate of SARS, because it was not relevant or related to SARS.
To tax, okay. Yes, now we'll deal with that when we deal with the operations leg.
Yes.
Okay, no, thank you, PP. Now, I just want to say, Chair, in rounding off this section, just to pose this question. You've taken us really through the journey of how you then got into your conclusions on this issue of the lawfulness and or otherwise of the establishment of the unit. Again, when we get to the judgment, you'll find that one of the, well, probably the most prominent criticisms is that you effectively embraced, let me put it that way, discredited, quote unquote, reports on these questions and put aside whether they were indeed discredited or not. But in your conclusions here, is there anywhere where you regurgitate or rely or adopt anybody else's findings, or were these findings from your own investigation?
I would want to say that mentioning these reports, we were showing that there's this investigation which was done by Skakane, done by KPMG. There was a legal opinion which was requested, and showing all the people who have investigated the matter. But then you will see that our focus was whether there was any violation of the legal prescripts. So if that can just be understood, that was the only focus. Yes, we checked the information, we couldn't ignore it. And remember, in our investigations as the ombudsman or public protector, we use such information as leads, meaning, for instance, on own initiative investigation, we can hear the Mkhulu, for instance, Hall issue, which was an own initiative investigation. Instead of taking it as is, or the Gupta leaks, for instance, we'll deal with it. But you use that, it's an information. It's not the gospel truth. It's not evidence. Then after these reports, then we will go to the source of the, okay, Skakane interviewed the following. KPMG dealt with this and they are saying the following. Okay, these are the laws which they referred to. This IGI report, indeed, they are the only institution which investigates intelligence-related issues, because one misunderstanding which a lot of people I interacted with, your legal advisor, Kavenda, Minister of State Security, Ms. Duba, because that was a very close session with her. And she was also saying, no, but public protector, SARS is not an intelligence department. I'm saying that's the very purpose of the investigation conducted by Skakane, referred that part to USIGI, and IGI is overseeing state security. So the main aim was just to check whether they operated within the law. Nothing more, nothing less. And in the report, there's several instances where I'm saying independently acquired evidence. So we use this as leads, and then we approach SARS. SARS, can you provide us with this? Okay, we also conduct our own independently acquired means of acquiring information. So this is why we came to the conclusion based on our own investigation, not just regurgitating or just taking whatever they are saying, but because of their findings and their conclusions, we are seeing that, but the information which we have, in fact, not information, evidence which we have, and what the law is saying, indeed, there is a violation of this law.
Yes, thank you very much. Okay, we'll deal with then with the third leg, and I think it will be quicker, Chair, because as I said, this probably of all the things you are investigating is the simplest, which is, as I say, the straightforward PFMA.
Exactly.
Whether something was procured properly or not. Anyone would know that in the public sector, really, you can literally pick out anything, whether it's a car or a computer, and the people who work there must be able to say, where did it come from? When did it come? And so on and so on. So the Chair, if I'd request that we break at this point so that before I start with the next leg. But I just, if you agree, I wanted just to deal with that issue that I had flagged, which I said it doesn't really fit in.
Maybe you can just assist me as a chair in the committee, just as we conclude this in a minute or two,
Yes.
to indicate in summary, what evidence are you placing on this establishment?
On the establishment. Sorry, I don't understand the question, Chair.
Having gone through
Yes.
this,
The history.
yes,
Mm.
and in detail,
Yeah.
I'm asking you the PP to just summarize in
Okay,
2 minutes.
perfect, perfect. Yes, thank you. Yes, I understand now. Yes, I think the church just wants to know. We now know that you've gone through all the elements of whatever you went through, and you therefore say that that allegation that the establishment was unlawful was established. So the chair now wants you to summarize as to how you reached that conclusion on the number 2 pillar.
Okay, I think we dealt with the conclusions, page 58,
Mhm.
because that's where I'm saying, Chairperson, the fact that the unit was established and we've shown that what section 209 of the Constitution is very clear that it's only the state security, defense intelligence, and SAPS intelligence. SARS approached Minister of Finance to approve the establishment, but they've already started doing that. And I'm saying, Chairperson, not stopping SARS to do its work. And I think we've shown you the observations which we had to deal with, that they needed to cooperate with state security agents. And hence Mr. Pilay's response and Mr. Gordon's response is also incorporated here, where they are indicating what is their view. So we've given them the OD in this particular issue, which is not true that we didn't allow them to respond. And secondly, the intention again for the committee, Chairperson, is that this investigation was conducted with an open mind as far as this issue is concerned. And we are showing that what the interception of evidence or interception of information, what it says about the operations of this particular unit. Also, I'm showing here the establishment part, that there was also a report by IGI, which we're still going to deal with it in details, where I was trying to acquire it properly, and I didn't regurgitate the reports of Abos Kakane, KPMG, Kroon, and everyone, which we're still going to deal with those. But I'm just showing that in the investigation as the public protector, we use that as information or as leads. Then we acquire our own. In other words, it helps us to know where do we start, or where the investigators are starting to investigate. So those are the traits of investigation.
Yes,
Thank you. That's helpful.
Chair, yes.
Now we can proceed.
Go to my, yes, no, thank you, Chair. Well,
Thank you.
and as you know, one question always leads to another. So I'm just going to piggyback on the chairperson's question and maybe zoom it more.
I thought you'd done with the.
No, I just want to ask one specific question, Chair. So your question has helped me to do that, just so that we don't go back to the so-called establishment issue. Yeah. I'd like you literally to just focus. We've heard everything you've said, Skakane and this and so on. But it would seem that if you like, the nucleus or the smoking gun in this whole thing is the memorandum to Mr. Manuel. Can you maybe in answering the chairperson's question in a more focused way, just zoom into the importance of that, given its content, its author, its destination, the comments around it, and so on. What to you as the public protector, what role did that play in just this establishment issue specifically. Thank you.
Thank you so much. I think that helps Chairperson also. It's just that I don't know why we didn't show it, and just to see that the preparer of the memorandum, and that is a reliable source document. Besides relying on Abu Skakane and everyone, this one comes directly from SARS as the
Remember when,
institution which we were investigating.
when Ms. Mkhwebane was here, we did go through it.
Okay.
So
Sorry, and that was the reason. We remember we said as far as we can, just for the sake of progress, we'll use the source document as the report. But maybe tomorrow morning before we start, we can display it. But
problem.
yeah, but for now, just because of the time, if you can answer the question.
It's very critical.
Yes.
Yes, it's very critical because the accounting officer signed on this.
Mhm.
The accounting officer acknowledged that already the unit is operating, and acknowledged that the unit is operating, and we would want to have an MOU with the NIA because what the unit is doing falls within the mandate of NIA or state security.
Mhm.
So this memorandum was acknowledging or agreeing that we know that this is not falling within our mandate, but we need state security agency to collaborate with us. So hence the comment by Deputy Minister Muleketi,
Mhm.
when he was noting the matter, actually is not approving, but just noting, but being concerned that you cannot, or this shows or reflects that it's a mandate of state security and you want to supplement, because the memorandum of understanding say they want to supplement. So it means the operations were there. And, but the key issue is, this is the document which we relied on, which is, it belongs to SARS.
Yes. Sorry, Chair, well, PP, we wanted to relieve you, but you've invited the next few minutes yourself. Can we then go to bundle A, page 7842, just so that we don't have to display it tomorrow?
Okay,
Just,
what are you looking for?
is that letter?
That letter.
Yes, just so that tomorrow we don't have to go
Yeah.
there. Yeah.
I see your sheet there. Make sure that
Oh.
we're never going to forget it. You know. So now the she has
The she,
revealed herself.
absolutely doesn't want us to go home. Thank you.
Okay.
So 7842, bundle A. Yes, no, the public protector is quite right. This is a crucial piece of, right. Okay, let's go through it slowly, well, not slowly, but carefully. You can see the letter, it's got all various stamps, 12. It's got various stamps, all dated 12th February 2007.
Correct.
And it's on the SARS letterhead, right? And dear Minister, and then it is, okay.
So
then
the
can you go
purpose-
through it? I
yes.
think the critical paragraph is 2.1 and 2.2, but just give us the context.
So the proposal or the purpose was to request approval to fund a special capability within NIA. So they wanted to fund it within NIA, acknowledging that this is not their mandate. But then they fund it within NIA to supply SARS and the law enforcement with the necessary information to address the issues of illicit economy. So the discussion then is what they were saying, the collecting of technical intelligence and the interception of the organized syndicates, which the country should be doing. So this is also...
No, please read the thing
okay.
Word for word.
Collecting
you're the one who said
technical-
we must bring
Okay.
it.
Advocate Mkhwebane, he is not the chair yet. So
Yes.
you, because I think you're mindful of your time, but I don't mind if you can do what is, but he is not the chair. Yeah.
Thank you. I've been put in my place.
Proceed, Advocate Mkhwebane.
Yes. Collecting technical intelligence invariably means I'm struggling to read.
It's quite faint.
Mm,
It's been copied all the time. So
yes.
so it's been part of the Rule 53 many times, I'm sure.
Yeah, I think that's why. So it deals with the
But you can summarize it, PP, I think the way you were doing.
intercepting organized criminal syndicates.
If I may assist,
Mm.
if you go to page 42, that's where the
Is
same
it
like
clearer?
the same-
Clearer there.
it's clearer. Yes, it's 42 of the report. Yeah,
Okay.
where we were reading. At least, okay, sorry. No, yeah, 42. No, I thought we were going to finish with that one and then come and read it from here. Yeah. But it's
Mm.
fine. I think everyone knows that it was to Minister.
Oh,
Manuel.
yes, yes.
Okay,
So page 42, page 5.2.7.
yes.
The memorandum requested approval to fund a special capability within NIA to supply SARS and law enforcement with the necessary information to address the illicit economy. The memorandum further stated the following: 2.1, collecting tactical intelligence invariably means penetrating and intercepting organized criminal syndicates. This is an activity for which SARS does not presently have capability, including the legislative mandate to manage clandestine activity. So I said it earlier that this encourages, or this acknowledging that they don't have the mandate.
Right.
Discussions are taking place with the national intelligence to supplement SARS intelligence capability. NIA is willing to create a ring-fence capability, provided funds are made available to cover personnel costs. All other costs will be covered by NIA. NIA is willing to formalize the above-mentioned arrangement into an MOU. 2.3, we therefore request that NIA's budget be increased to fund the creating of this special capability.
Okay, Tsepo, can I go back to the actual letter now? All right. Sorry. Okay, you've read, I think, what are the important parts, Chair. Can you then just go further up?
The estimated personnel costs.
Yeah, all right.
Yes.
So
which
then
is-
the estimated personnel costs.
2007-8, it's 13 million. 2008-9, it's 17 million. 2009-2010 was 18.8 million.
Right.
Mm.
And maybe let's just pause there, Chair, to jump a little bit ahead on the equipment issue. Just on that budget, when we deal with the equipment issue tomorrow, one of the issues that you raise in the report is that such a unit costing as much money as this, there's no way that it didn't have any equipment. And if it did, then you would have wanted to know how it was procured. I just wanted to flag that just so that these amounts can be kept at the back of
At the back of my mind, yes.
All right. Next one, 2.5. Right. Oh, sorry. Yeah. Then just comment on those, what we see there.
So this document again, Chairperson, I said, these are the kind of documents which I will encourage officials to rely on instead of media articles or just some reports, but those reports are leads. So here it shows that this was prepared by the General Manager, Enforcement and Risk. We know that it was Mr. Pillay, and then the commissioner then was Mr. Kodan, the commissioner of SARS as the accounting officer. Then the deputy minister, then it was saying approved or not approved. So his comments were, as we've captured here, asking this is the responsibility of NIA. And I see that you'd want maybe to supplement that function or the existing units function within SARS. Then the Minister Manuel then just approved this submission. So communications in government, that's how it is, because once it's signed by the minister, when you request that approval, it means it was approved.
Yes. Okay. So as far as approval is concerned, this was clearly directed to the
On the
minister,
establishment.
prepared by the relevant official, Mr. Pillay, signed by the accounting officer, Mr. Kodan, countersigned by the deputy minister, and signed, and therefore it was, as you say, a proper legal document or memorandum. Okay, thank you, Chair. I think I hope that covers your question, Chair. Yes.
Yes, thank you.
Just then my issue again, just so that we don't spill it to tomorrow.
Sure.
I want, this is, shall we call it homework, not just for tomorrow, but something that I just wanted to highlight, which postulates, particularly into SARS, regarding the role of the public protector. SARS, CX, when I say SARS. The role of the public protector. Remember, there's this debate about whether your mandate includes saying anything about the Constitution and so on.
Yes.
Yes. If you go to section 181, Chair, 181 of the Constitution, that, as we know, is the governing provision, not just for the public protector, but for all Chapter 9 institutions.
81.1.
Yes.
Okay.
181.1, yes. Now, this talks about state institutions supporting constitutional democracy. And it says here, the following state institutions strengthen constitutional democracy in the Republic. And the first one is the public protector. Now, again, addressing the chairperson, the committee, and the public, what do you understand about that concept? That the role of these Chapter 9 institutions, after all, is to strengthen a constitutional democracy. Does that mean that there are areas within the Constitution or the constitutional framework, including the Constitution itself, where you are not allowed to go?
Definitely, it's very clear for all the Chapter 9 institutions. We should be assisting actually the country to implement or to make sure that the Constitution is a living document and is applicable to all citizens. Therefore, this Chapter 9 and Section 181 is very clear that we are there to support constitutional democracy. And how we do that, there should be transparency, there should be cooperation, they should even assist us in the performance of our responsibilities. So I think that was interpreted in the Nkandla judgment, where we can access any information. You know, you go deep into raw state power, whatever information you require. Hence, in the number of engagements with in this investigation, I was very clear that you cannot indicate that you can't give me the IGI report because this is necessary for the performance of my responsibilities. So it's like then stifling or not cooperating with us. I think SARS, it's a number of issues which we had challenges with.
Yes,
So Advocate Mbofo, so it is also fitting that the National Assembly develop rules for all of these institutions.
That's correct, Chairperson, not only for the public protector, all these institutions, yes.
Okay, thank you.
yes, and for the sake of completion, let's then link that to 181.3.
Correct.
Can you comment on that one?
So this one is at the core of what is expected from other organs of state.
Including the National Assembly.
Yes.
Yes,
Through legislative and other measures, must assist and protect these institutions to ensure that the independence, impartiality, dignity, and effectiveness of these institutions is guaranteed. So I think we will deal with that, possibly we'll deal with that when we also deal with the evidence of Public Protector Sakoni, because it was like, okay, as the National Assembly, you've established this committee. And I think in my statement also, we indicated that what are the expectations from me and how did they assist me in ensuring that they assist me in getting any information in the ensuring that I'm independent, I'm impartial, the dignity of this institution and effectiveness of this institution, especially the dignity. I think I've mentioned several times, or there was an instance where I mentioned that there was a stage where I also mentioned with portfolio committee that, you know, I feel like being attacked in all angles. And the very same mother as well, being the speaker, also joining in, or the parent joining in to victimize or to deal with me, instead of the National Assembly protecting me as the incumbent in this institution. So this is very critical, especially section 181.3 for any other chapter 9 institution when we are performing our work under this. And as well, it was even worse when I had to be clobbered with personal costs in my private capacity. And a lot of those, what does it say to this? And how do you assist and ensure that I maintain my independence, impartiality, dignity, and effectiveness, which is very critical, because the minute you disarm or you cause this institution to operate with fear, or all these institutions to operate with fear, then it means the citizens are on their own. They are not protected.
Thank you, Chairperson. In my language, they say drops mic. I think that's where we should stop it for today. Thanks.
Thank you. I missed that. Maybe it's better if I
No,
missed it.
you won't understand, Chase, for the youngsters like
Okay,
us.
okay. Thank you. Thank you. Thank you. The time now is just about 18 minutes plus 5. We are going to adjourn for the day. Pause there and start tomorrow again at 10 to proceed with the remaining 4 areas under that. And I'm asking that members, so that we don't repeat today's late start. We'll start at 10 tomorrow. Thank you very much.
Thank you,
The meeting is adjourned. Thank you.
Recording stop.